My lord, with notice to other side, I am mentioning hearing of matrimonial appeal, my lord.
Not now. Yes.
Leave to mention one matter. Your lordship dispose of the writ petition arising on the order of the tribunal with a liberty to the petitioner to file appeal against the vesting order within a period of 3 weeks from the date of passing of your lordship
It
order.
appears to be mentioned, right? To be mentioned, we'll
Fine.
extend. Give a notice to the other side, Mr.
We notice. We notice.
Yes.
Second appeal dismissed.
My lord, order 41, lordship.
Yes. Yes. এটা কি লিখে দিতে হবে রেজিস্ট্রেশন
My lord, application.
Your lordship, with leave of Justice, Honorable Justice Subritin Bhattacharya, may I be permitted to mention a matter which was previously listed in a different bench presided by your lordships. We have filed a recalling application in the same.
hand over the slip whenever we sit we'll add this. এটা জাস্টিস ডকুমেন্টের সঙ্গে আছে দেখে নিন
Grateful, your lordship.
Next.
One order 41 application. Application in
Yes, yes,
Calcutta
sir.
was.
Your lordship, may I be permitted to mention a matter? Your lordship, it's a first appeal hearing matter for inclusion.
Application. My lord, may I be permitted to mention one matter for hearing?
No. Call on the list.
Our written notes,
Read me.
but they are ready, but not ready to be filed. But we will be
Tomorrow then
But our notes are ready.
you are for the
Appellant.
appellant.
If it
The written notes of the appellant filed today be kept on record. So on the prayer of learned counsel for the respondent, the time for filing written notes by the respondent is extended till tomorrow, till Monday, that is December 1, 2025,
grateful,
when the matter will be listed under the heading to be mentioned for such purpose.
grateful.
Very good. Thank you. Yes. Next. এটা এখন পাঠাবেন না দিলে ওটা হ্যাঁ সোমবার
I'm for the appellant, my
I am filing written notes of argument.
yes
That one indulgence I am seeking, madam, the judgment compilation, and we will file in course of the day with the officers.
Very good. Written notes of arguments filed by the parties be kept on record on the prayer of learned counsel for the respondent, comma, the respondent is permitted to file the compilation of judgments during the course of the day. Hearing is concluded and judgment is reserved in the matter.
Grateful, your lordship.
পড়ে যাবেন না নিজে পরে ফাইলটা দিন
Fourth, my lord, on the last occasion,
yes তিন ফাইল we'll just check up our previous order
lordship, 25th November 2025, lordship. Kindly seize, my lord, the last.
please wait me sir yes let's see. Two directions why not complied?
My lord, he has come with this, he has come, my lord, and he has some written, my lord.
What is his answer? Tell us.
His answer, my lord, as I have gone through, my lord,
Tell us the crux of this, Mr. Galib.
crux is, my lord, that the land is a vested land through Sudhir Patra.
There were two directions of the High Court. Why didn't he comply?
No, prior to that, my lord,
Prior to whatever happened. Specific direction, two directions by the High Court. Why didn't he comply? He doesn't have the right to reopen the order of the High Court.
lordship,
Whatever happened previously. How can he do it? Specific direction was to correct the records of rights. Two directions. Why didn't he comply? Why shouldn't we be behind the bars? A wrong message is going, Mr. Galib, by people like you defending these people.
lordship, kindly, my lord, don't take me in the amiss.
We are taking you amiss. Why are you defending him?
No,
He should be apologetic and behind the bars unless he is.
I'm not.
Two directions of previous benches, Mr. Galib. Sorry. You cannot reopen that. This person, BLLR, doesn't have the right. He's not the Supreme Court. There are two specific directions by the High Court. If not more, we don't know. We have recorded in our order.
Two, lordship. But, my lord, may I, my lord,
First, it was a direction that the title suit decree that has to be complied with, and to correct the records of rights incorporating the name of the petitioner. There was no leeway for him to dilly-dally or give further hearing. The
lordship,
second direction was that previous was not complied with. That's why a direction was given. He is to immediately correct that. Why didn't he?
but, my lord, this,
We'll impose exemplary fine on him, Mr. Galib, and he'll comply immediately. By the course of this week, he'll do the correction.
Lordship, he has given such a submission. May Lordship have a look at.
No, we won't reopen the previous directions. We are not entitled to even the High Court is not. He is not in review.
No, because
He is not in review.
they are claiming me through Putimoni Dashi, but before that, Sudhir Patro was the intermediary. The land got
Whatever, there was a direction to correct the records of right in their name.
That is that.
Two directions. Have you preferred an appeal against those?
Certainly not, my lord.
1 month's salary, Mr. Khalid, will be deducted from his salary. And he'll comply immediately. And we'll put it as to be mentioned on Tuesday. Yes, please come forward. You come forward. Yes, what is your explanation? Why didn't you comply? How can you reopen it? Two directions of the High Court. You are a BLLRO. You are an educated person. You're supposed to comply with the law, sir, not to flout it. If you people like you do that, what will the common man do? And our power is not that we are musclemen and we go and implement the orders. The power lies in a judicial fiction that people will comply with our orders. That's the rule of law in a country. There are two specific directions of the High Court. Why didn't you comply? How can you reopen that? You can reopen that in an appeal before the Supreme Court. Definitely. If you win that appeal, yes. Two directions. First, not complied with. Second, because you have not complied with, again another direction. Now you are saying something behind the previous order. How can you do it? The BLLRO, the concerned BLLRO, is present in court today personally and files a written submission, thereby tendering unqualified apology and seeking to explain the non-compliance of previous directions of this court on grounds of law and fact. Full stop. However, it is evident from the said explanation that the BLLRO has sought to go behind the previous directions of the High Court and to justify his action in not complying with the same. Full stop. In our order dated November 25, 2025, we had categorically recorded that by an order dated March 2, 1984, passed in Civil Rule number 9592 within bracket W of 1981, a learned single judge of this court had made the rule absolute, and a writ in the nature of mandamus was issued, directing the opposite party / authorities to act in accordance with the judgment and decree passed in title suit number 262 of 1961 of the Second Court of Munsif at Midnapur, and more importantly, to correct the records of rights incorporating the name of the petitioner in respect of the land described in Annexure C thereto. Full stop. Next para. We further recorded that the authorities, even after such direction, did not learn the lesson, which necessitated a further writ petition to be moved by the present petitioner by way of Civil Order number 9121 within bracket W of 1988, which was again disposed of by another coordinate bench of this court on August 16, 1988, by specifically recording that in spite of the representation made by the petitioner for the purpose of implementation of the previous direction, the respondent authorities had not carried out the necessary correction or the direction given by this court in the previous civil rule. Full stop. Next para. However, even thereafter, the concerned BLLRO, who is present before us, did not comply with the order of the court. Full stop. Next para. We are fully aware of the legal position that orders of this court are amenable to appeal / challenge before superior courts. Full stop. However, in the present case, no such challenge was preferred at any point of time. Full stop. Therefore, the two previous directions of this court attained finality. Full stop. Hence, there was no scope or leeway for the BL and LRO to seek to reopen such directions and go behind those directions by adjudicating the matter afresh on merits. Full stop. In such view of the matter, we are of the clear opinion that the BL and LRO has flouted the order of this court, repeated directions of this court, thereby making the BLLRO liable to pay costs to compensate the harassment suffered by the petitioner. Full stop. Accordingly, we direct the BL and LRO to immediately comply with the previous directions of this court and correct the records of rights in favor of the petitioner, comma, by incorporating the name of the petitioner in the concerned land. Full stop. Such compliance shall be done within 1 week from date. Full stop. Next para. The matter shall next be listed on December 4, 2025 for being taken up at 10:30 a.m. Full stop. WPLRT 185 of 2025 is allowed accordingly in terms of the above direction. Full stop. Next para. Furthermore, comma, due to the harassment costs to the petitioner, comma, the BL and LRO shall, comma, personally, comma, pay costs of rupees 50,000 to the petitioner within a fortnight from date. Full stop. Next para. The BL and LRO shall pay such costs from his own salary and not from the coffers of the state. Full stop. Next para. Returnable date যেটা 3rd করেছি ওটা 10th করে দিন, 10th December. Full stop. Next para. On the returnable date, comma, when the matter will be listed under the heading to be mentioned, comma, the personal appearance of the BL and LRO is dispensed with. Full stop. However, comma, a receipt showing the payment of costs as directed above shall be furnished in court for the records on the said date. No address possible. Yes. The explanation file today be kept on record. Yes. Pay the costs and put in the receipt on 10th. And we have to be satisfied, Mr. What is your name, please? Mr. Mukherjee, will have to be satisfied that it has been paid from your pocket. Is it clear? Any doubt in understanding what we say? Thank you. Next. Yes.
Your Lordship, on item number 5, I'm appearing for the respondent bank ICICI.
I appear for the proposed.
Why was it to be mentioned?
My lord, it's for.
This is for the correction of the name, which is wrongly correction of the name.
Whose name is Arindam
Media
Mukherjee?
Council, it would be Arindam Banerjee.
Learned counsel for the respondent submits that the name of Mr. Arindam Banerjee, senior advocate, was erroneously recorded as Arindam Mukherjee in the order dated November 24, 2025. Full stop. Let the said order be deemed to stand corrected to the effect that the name within double inverted Mr. Arindam Mukherjee double inverted shall be deemed to be Mr. Arindam Banerjee. Thank you.
Much appreciated.
এগুলো কষ্ট মানে এটা কোথায় ফেললে? ওটা বলেছিল দিতে না পেপার বুকটা, ওটাই জমা দিয়ে
Oh, বলেছি বেঞ্চ প্রিসাইডেড ওভার বাই আমি
Lordship, item number 6, kindly fix it at 2 p.m. Lordship. Mr. Dhar is for the appellant Lordship. Due to some very personal difficulty, he has not come to court
in the morning.
till now. Kindly keep it at 2 or
Keep it at
Lordship.
no difficulty. Ms. Shina, no difficulty. Very. কোন অর্ডার রেকর্ড করতে হবে না 2 p.m. এটা 2 p.m. এ কল। This will be the first matter 2 p.m.
Grateful, my lord.
Yes.
I am appearing on behalf of the respondent petitioner.
Yes. You were arguing, the respondent was arguing.
Learned GP is for the appellant. He was arguing on the last occasion, Your Lordship.
You are passing it over for 10 minutes. Please inform the other side if you can, the appellant. But if they don't appear, we'll cancel the part. Yes.
Order of stay, Your Lordship. I am suffering.
We'll vacate that. We'll vacate that. We are passing it over for 10 minutes. We'll call it at 11.
As Your Lordship.
11টার সময় আবার ডাকবেন যদি না কিছু চললে মনে করিয়ে দেবেন।
I appear for that.
Yes, Mr.
I'm for the
Yes, Mr. Dey. Just remind us, Mr. Chakravarti, it has been argued previously.
Fact I am submitting in brief.
Yes, because Justice Bhattacharya was not there in the previous bench. Yes.
The petitioner
In a
was,
nutshell, you can remind us.
yes, the petitioner was granted a mining lease for extraction of sand. The system of auction is they will have to pay 1/3 of the bid amount first. The lease deed shall be executed. There is a time limit for payment of the rest bid 2/3 amount within 2 or 3 installments. For some extreme financial problem, the petitioner failed to pay the rest part. Initially, there was an order. The authority directed the Blockland and Land Reforms Officer do not issue any transit pass until and unless the amount is paid. My business was stopped for a certain period of
This is mining of sand.
mining of sand. I collected the money, I paid. It was unconditionally accepted. A certificate was issued that there is no further mining due. And I was allowed to pay, carry on the business. In the meantime, I have lost 15 months. 15 months of time within a period of 5 years. Out of 60 months, 15 months were lost.
Lost because of your fault. You did not pay. Why should
I am coming to that point, not whether it is my fault or not, or whether after that I accrue the mining right or not. In the meantime, 60 months have passed. I made an application.
60?
5 years, 60 months.
5 years.
I made an application
So
for
5 years passed in what? In doing what?
total leasehold period is 5 years.
5 years. You paid the money after how much time?
I paid the money during the leasehold period.
But that means how long after the scheduled time?
Approximately 1 year and a half.
So you had 3.5 years left, or 4
3.5 years left. I was allowed to utilize it. Now, I made an application for extension of the period.
For that period?
For that period for which my business was stopped.
Why should you be granted that liberty? You were responsible for making late payment.
There the point comes, my lord. I shall add on these points. It was rejected by the authority. I preferred a departmental appeal. That was also decided against us. We moved the writ application. That was also decided against us.
You have challenged that?
That order. All 3 orders, my lord.
Let us see the writ court's order first, Mr. Chakravarti. We will just then come back to you.
My lord.
Section 5 has been allowed in this matter.
Yes.
There was a review also.
Yes, a review application was also filed.
You are challenging the review order or the main?
No, both.
Both.
Yes, madam. Now both. Your lordship, make the board. Both the
The main merits, yes. Review might have been little scope, so we'll see the main order first.
As your lordship is pleased.
Main order is dated 1st of May.
Main order is dated
1st May.
1st of May. ঠিক আছে, দেখেছি আমি।
After making the payment, you were given the road challenge.
Yes, that was given for the rest period.
Mr. Chakravarti, 2 principles come in here. Obviously, you know that. That first is one cannot take advantage of one's own wrong. Secondly, is that the court cannot rewrite the contract. So both apply here. your fault. You paid late, so road challenge were rightly not given to you because you were at jeopardy of the agreement being cancelled. In fact, your bid being cancelled, but they did not do that. They permitted you to work.
Yes,
For
I
that
was
period, why should the contract be extended? That will be rewriting the contract, which the court cannot do. It's well settled. It will be over before the next matter when you call at 11. Your best case, Mr. Chakraborty, what is your best case?
My lord.
You relied on Rule 21 or something like that.
Yes. Rule 21.
And 10 to.
Allow me to place Rule 21 first.
Do that.
21 and another clause in the lease deed.
Please, absolutely. Force measure.
Force measure.
You argued that. Force measure. What is the force measure? You are the force behind the delay. This is the major force.
My lord, may I
There is
place
nothing in your
case?
case. Nothing in your appeal.
My lord, may I?
We have seen that force measure clause, page 61.
Yes. My lord, am I to place section 21 or not necessary?
Rule 21.
Rule 21.
Only that, because you have seen the force measure clause.
Yes.
Because you relied on Rule 21 before the learned single judge.
Yes. Rule 21 says lapsing of lease.
What is the page number, Mr. Chakraborty? Page number? Where do you find? It was a different copy. Where do you find Rule 21?
Rule 21 from the book, my lord.
Oh, আচ্ছা
West Bengal Minor Millionaire Concession Rules 2016.
আচ্ছা ছিল আগেবার ওই ম্যাটারের সময় এসেছিল একটা বাঞ্চ আমাকে দিন একটা বাঞ্চ নিজে নিন ওই যে ওরম দেখতে একটা বাঞ্চ আমাকে দিন ততক্ষণ দেখতে থাকি lapsing of lease this
Lapsing of lease.
yes please place it
Rule 21, 1 and 2 are regarding lapsing of lease. Right to apply for extension comes in section sub-rule 3 and 4.
yes
On receipt, I am reading the 4, sub-rule 4.
please
The
absolutely.
state government or the lease granting authority may, on receipt of an application made under sub-rule 2, and on being satisfied about the reasons for non-commencement of the mining operation or discontinuance, allow the commencement to continue of such lease. Where the explanation clause is there.
You do not fall within any of these explanations. You do not fall within any of those.
My lord, what I submit, I am precisely submitting the points of law, my lord. Kindly come to page 67 of my stay application. This is the order by which my business was stopped.
Yes.
It was issued on 24th of September 2019.
Right.
The additional district magistrate is instructing the block land and land reforms officer, as per decision taken in the hearing on such and such date regarding deposition of bid money, the lessee, Dilip Mondal, auction identification number such and such, was instructed to deposit such and such within November 2019. You are instructed to stop challans against the lessee in the upcoming session until and unless instruction is given from this end. 2 points come, my lord. Firstly, I was permitted to submit it within November 2019. But before expiry of that, on 24th of September, at a premature stage, it is stopped. The authority gave me time for some extension for payment. Before expiry, the stop
What is the extension order?
My lord?
Extension by this only.
No,
Extension. There was
the third line. He was instructed to deposit rupees such and such within November 2019.
but your lease does not take effect. In November 19 was an outer limit. Your lease does not take effect unless you pay the entire amount.
My lord, there is a notification.
It shows that.
That is page
79.
79. Yes, Annexure PI, page 79. I'm thankful to Mr. Paul. It was dated 22nd of May 2017. That applies in case of my lease.
All right. Yes.
Clause 1. The successful bidder who have deposited 1/3 of the bid amount may be allowed to commence mining operations and lease deed may be executed. Clause 2. The balance of bid money shall be payable in 3 installments with a gap of maximum 45 days each from the date of first installment, which shall in no case exceed the lease period or the closure of mining operation.
This is
Here
your best.
the law was slightly
Yes, this is your best
Change.
case. Huh?
upon payment of 1/3 bid amount, execution of lease deed and commencement is permitted.
Commencement is permitted.
Commencement is permitted.
Ajay,
Now-
this notification was published before your lease deed or after?
22nd May 2017. My lease
Date? Yes.
was registered on 18th of December 2017.
So this is prior.
This is prior.
Right.
Now, I
So
submitted clause
This governs you. Therefore, they were to permit you to commence mining.
permitted to commence.
That could not be restrained.
Yes.
So you want an extension of which period from that notice till
From that notice till
when you were permitted to commence? You are stopped from.
I was allowed from November 2019. No, okay. No. That is the wrong. No due certificate was issued on 22nd of April 2022. So from 24th of September 19 to 22nd April 2022. This is the period of closure.
When did you pay? You paid within November.
No, I paid in April 2022.
Then
Kindly allow me to finish my submission, my lord. The first point is that it was a premature notice. I was stopped. And secondly, my lord,
the balance amount of bid money shall be payable in 3 installments with a gap of maximum 45 days, which shall no case exceed. Acha. So you say that you had a right to pay before the expiry of the lease period.
before the expiry of the lease period.
So
Here,
the entire time was with you. So
Entire time
even
was-
if you deposited in April, I mean, whatever they said within November or whatever, you had a right to commence mining and continue mining,
continue mining
pay the rest of the amount before the end of the lease.
before the end of the day. And secondly, my lord,
Yes.
whether the stop work orders could be issued or not. This is the question, whether this is legally valid or not. Kindly allow me to place section 25 of the Parent Act, that is Mines and Minerals Development and Regulation Act. My lord, may I hand up my book?
No, but that will be one book, so we must have this book.
Section 25.
Now let us find out if we have the book, then why? Give us 2 minutes time.
For the time being,
Where? Dipankar, on a turn. Yes.
recovery of certain sums as area of land revenue, any rent, royalty tax, fee or other sum due to the government under this act or the rules made thereunder or under the terms and conditions of any mineral concession may, on a certificate of such officer as may be specified by the state government in this behalf, by general or special order, be recovered in the same manner as an area of land revenue. So if the authority opts for collection of the balance amount, 1/3 is paid, 2/3 is not paid. They gave a time expired, so it has fallen due.
That can be recovered by them.
That can be
But
recovered by
work
them.
cannot be stopped. Mining work cannot be stopped.
My submission is that, my lord. This was issued in utter violation of section 25. Therefore, it has no legal sanctity. An illegal drive was made. The authority stepped beyond their jurisdiction and issued a stop work order. Till my full payment is made, April 2022, the work remains stopped by an order which is violative of the Parent Act, section 25. And my second point is that, my lord, kindly take into consideration the object and purpose of payment of the bid amount. It has a quid pro quo relation with my mining right. So if it is the case that my lease is cancelled, that is one thing. 1/3 paid amount is forfeited, my lease is cancelled. I had no case to make out before the court, before the honorable court. But after the time granted by them, when they accept the money and issue a no due certificate, kindly come to page 80 of my petition.
Is there any provision of extending the lease period, or your remedy lies in damages?
No, my lord, there is no provision of extending of the
Lease, how can it be extended?
My lord, under the force majeure clause or under section 21, if we take the spirit, if there is any obstruction of business for some reason which is beyond my control,
Force majeure, this is not force majeure.
then I am entitled.
Not force
In that
majeure,
case,
but
my
an
lord,
illegal, this is an illegal act on their part at best.
my
Or at worst. I mean, an illegal act in stopping your mining work.
my
If
lord,
there is an illegality in stopping that mining work during this period, 2019 to September 2019 to April 2022,
my lord.
then Mr. Chakraborty, you are definitely entitled to damages. But lease period, how can it be extended? Lease is a
Your lordship,
bipartite agreement.
kindly consider
Damages, maybe you are entitled
when they accept it subsequently, unconditionally, two legal consequences occur. Firstly, the delay in payment stands condoned. And secondly,
they have not cancelled your deed.
No, they did not cancel.
So therefore, that question becomes irrelevant because delay is condoned. Nobody is saying it is not
And
condoned.
I have accrued a substantive mining right, my lord. Now,
yes, you had. But that period when it was stopped, Mr. Chakraborty, what is your remedy? How can we rewrite the contract, or even they rewrite the contract?
my lord, apart from the
extended period of the lease, that is not a remedy.
Apart from the provisions, express provisions of the relevant law, if I may not submit before your lordship under the doctrine of equity, silence of statute does not have an exclusionary effect. That there is no express provision, that does not mean that it shall operate as a prohibition. So, my lord, when they accept the entire amount, bid amount, the legal consequences, I accrue a full mining right.
Yes.
Usufructuary right for 60 months.
For that period.
For entire money is paid, entire period is.
Entire period of the lease, which was entered into by.
Yes. Now, of that entire period, 15 or 60 some time.
3 years were almost lost.
Almost lost. And that was by a.
Why did you challenge this? When did you challenge this notice? After the lease period?
No, actually.
The writ petition immediately after this notice was issued. You should have challenged this notice immediately.
Notice was not a challenge because at that relevant point of time, that provision for paying for extension was there.
Yes, but they had stopped mining work on 24th September 2019.
2019.
They could have immediately come up before the writ court and said that they cannot stop.
No, that they could not do.
Did you, before the writ court, what was the challenge in this case? What did you
challenge? I challenged the rejection of my prayer for extension. Now I am not challenging that notice. Then, and during the course of this period,
this has attained finality. So we cannot reopen this.
One point, my lord. I have already submitted before you that submitted before the lordships that the notice is
fine, Mr. Chakraborty.
Violative of section 25 of the Parent Act. What I submit, subject to your lordship's correction, it remains violative. That position of law does not change.
Whether I challenge. What is the bar in section 25? Why is it violative? There is no bar in section 25.
25 is stated that by a recovery process,
no other recovery process is permissible. But yes, you have a point in saying that as per this notification, you have that right. Section 25 does not debar them from stopping mining work, nor does it allow stopping mining work. It only provides an alternative mode for them to recover.
It
And this was not a recovery.
it expresses the mode of recovery.
But Mr. Chakravarti, this was not a mode of recovery. This was your work was
Penal measure.
penal measure.
Penal
Penal measure, exactly. Penal measure for you not having, not even a penal measure, because they say it was a non-starter because you did not pay the entire amount, which was wrong. You should have just challenged this. How can we look into this now? Even now you have not challenged before the writ court. I mean, we are the appellate court.
But I am submitting the legal position, my lord. I am not challenging that. I am challenging their rejection order to grant me the extension.
So
Now,
let us-
question is,
yes, silence of statute. I mean,
even if I do not challenge, it stands violative of section 25, my lord. When there is a specific
we have
provision,
some reservation there. This is
If
not
you-
violative of any provision. Not violative of any provision apart from this notification of 2017. 2017 also does not debar.
no,
It says may be allowed to commence. We constitute to be violated.
Yeah, it permits me to pay during the subsistence of my lease period.
Crucially, the successful bidder who has deposited 1/3 may be allowed to commence mining operation and leased it. This may be allowed. They may say it's discretionary, but we may constitute to be shall. But even then, that has to be done. The damage has to be quantified. What damage you suffered for this period? Extension of lease we cannot. The court cannot grant, nor can they. So let us consider that regarding damages, what Mr. Dey has to say. Let us hear them. Yes, Mr. Dey.
My lord, if your lordship will see.
Why shouldn't we make it clear that they are entitled to claim damages?
Yes, my lord, only 79.
79, yes. 79 is very important.
Yes, my lord. That is the rules abide by the.
Yes.
That is first one, my lord. The successful bidder who have deposited 1/3 of the bid money. First, my lord, bid money was deposited. May be allowed to commence mining operation and lease deed may be executed. My lord, now second point. That is the balance amount, how to be paid. The balance amount of bid money shall be payable in 3 installments with a gap of maximum of 45 days from the date of first installment. First installment after paid, my lord, within 45 days he must pay this.
No, you are meaning, Mr. Dey, that the first installment is that 1/3.
Yes, my lord. Now the second installment will be paid. That is within 45 days. That is my lord, moot question.
Mr. Dey, can you say that? Because the language is the balance amount of bid money shall be payable in 3 installments. Now, among these 3 installments, which refer to the balance money, not to that 1/3.
No.
The balance money will be paid in 3 installments with a gap of maximum such and such each from the date of first installment. So the first installment will be the first installment of the balance money, not the 1/3. 1/3 is the.
No, my lord, 1/3 money, that is according to the provision, my lord. 1/3 money will be paid to the.
1/3 has been already paid.
Yes, my lord.
That cannot be counted as the first installment because the language is the balance amount shall be payable in 3 installments.
Yes,
right?
my lord.
So that all the 3 installments have to pertain to the balance money, not to the original earnest money. So the balance amount will have to be payable in 3 installments means that the first installment will be the first installment of the balance amount.
The balance amount of bid money be payable in
Right.
installment with a gap of maximum
2/3, yes.
each from the date of first installment.
Balance means 2/3.
Yes, my lord.
2/3. The first of that 2/3 will be paid. Whenever it is paid, that has to be paid within the lease period.
In 3 installment with a gap of
Maximum of 45 days each
From
from the date
the
of first
date
installment.
of from the date of the first installment.
The first installment, how can you say the first installment is the 1/3 deposit? That
That is-
1/3 deposit cannot be equated with any of the installments of the balance amount. These 3 installments pertain to the balance amount, installments of the balance amount. So the balance amount has to be paid, that is 2/3 has to be paid by 3 installments. Gap between each of the installments is 45. So therefore, the first installment cannot be the earnest money, 1/3 money, but the first installment of the 2/3. That is very clear from the language.
The balance amount of the bid money shall be payable in 3 installment with a gap of maximum 45 days each from the date of the first installment.
If the language was each from the date of first installment, Instead of first installment, if it was the earnest money or the 1/3 amount, then we could have understood you have a point. But here 3 installments with a gap of 45 days each from the date of first installment. So each, I mean, then we have to constitute further that suppose the first installment is taken to be that the 45 days from the second installment will also, the gap from the second is also 45. So those are, this is speaking about the installments of the balance money, not the earnest money. We respectfully differ from you on that. So if you differ from you on that, they have a right in damages. That we can give them liberty to apply before the court. But yes, even before you opening your mouth, neither you nor we, the court, has a right to rewrite the contract and grant them an extension of time. And also, we cannot direct you to grant extension. That's a discretion.
Contact, if your lordship will come to the page 37.
Yes, 37. Balance amount that is there also there.
Balance amount that is remaining 2/3 of the bid money shall be payable by the lease in pre-negotiation with a gap of maximum.
This has made it
45
more
days
clear.
from the date of the installment which has already been paid up.
It has made it clearer.
Clear than the notification.
Not said. The balance amount that is remaining 2/3 shall be payable by the lease in 3 equal installments with gap of maximum 45 days each from the first installment. Oh, acha, which has already been paid.
Yes, my lord.
Ah, this changes the.
Yes.
This is the earnest money was paid on 27th.
Yes, my lord.
First installment was paid on.
এইটা পুরো ল্যাঙ্গুয়েজটাকে ওটার সঙ্গে নোটিফিকেশনের সঙ্গে ওটা তো চ্যালেঞ্জই করে ফার্স্ট ইনস্টলমেন্ট করতে পিরিয়ড মধ্যে ফার্স্ট ঠিক এটাতে অল্টার কিন্তু ও তো সাইন করেছে Mr. Chakravarti, my learned brother has a point. Although this differs from our interpretation of notification.
Milord.
But this is a contract which you agreed, entered into with them. This is a commercial contract. You are not a naive rural person that some impression given and loan taken. Not like that. Mining operation, full-fledged commercial person.
Milord.
So you entered into with your eyes open. So this was the interpretation lent by you also by signing this contract. So then, Mr. Chakravarti, then probably you don't have a case.
But Milord, when they subsequently accepted my delayed payment.
For that, they did not cancel the contract.
No,
That is the only fallout which can follow.
They subsequently accepted my delayed payment unconditionally, and they are by their conduct the terms varies. Had it been a case of cancellation, I had no case.
So you say that this acceptance then by necessary implication should also include acceptance of clause 1.
Acceptance
because there is no distinction between cancellation and
binding operation. Yes, page 68, my lord.
Cancellation, my lord. Next page, my lord. If your lordship will see page 38, first paragraph.
That cancellation clause did not come into operation.
No further relaxation in the periodicity. Yes, the mining shall be cancelled. So you have not cancelled.
Yes, my lord.
Then, sir, you have not cancelled. Then you acceded to the entire thing. The entire notification, then you acceded to. The moment you don't cancel, you have not cancelled. So you accepted whatever it is. That payment was accepted in its entirety. If that payment is accepted, you give a go by to not only 2 but 1 also. Because if you accept that and not cancel the agreement, then 1 also comes in. Because 1 does not have any such rider. Rider is in 2. 2, it says that balance has to be paid within that period. And 3 also says payment of consideration appropriate. So this clause 6 at page 37 is violative of notification in our. If that be so, we'll keep it open for them to ask for damages. They'll have to satisfy the court as to quantification, but it's open to damages. The relief they have sought in the writ petition, no. We are not interfering with the writ court's order. But we'll add 1 line, which will be damaging to you to some extent, that they will be entitled to ask for damages if entitled to in law. We'll keep that question open. But we'll give our interpretation, why we say that.
Page 68 is the payment certificate, my lord.
68 payment started.
Payment certificate, payments, no due.
No, nobody is disputing. So there is none of them will dispute that payment. You are for whom?
I am for the response number 2.
Who are you? You have been given the next mining lease.
Next mining, not only grant of next mining lease, but the carrying order or the challan. I am the authority as after 2021 rule came into effect that I will issue the challan for transportation or selling the sand.
So what is your stand formally?
No, Lordship, this is a particular lease granted by 2016 rules. After 2021 rule came into effect, my client has been designated as the nodal agency for grant of mining lease. Now, after the policy which was issued prior to this rule, 2021 rule, that says that the existing leases after its expiry cannot be extended. After the expiry, it will be vested to the mineral development. That is my client. Thereafter, they will put into auction and grant fresh lease.
Understood. Therefore, that also substantiates the contention that it cannot be done.
On this point, my lord, what I subject to your lordship's question, even in 2021 rules, there is no express provision that will not be extended. It is also silent. And second point,
21 rules is with you. This 21 rules.
No, it is 21 rule is not there.
And secondly, my lord, prior to coming up in operation,
your learned friend is saying that there is a specific provision that existing rules.
Mining policy. Let's see, prior to the rule came into effect, there was a policy in 2021. It was notified on 30th July 2021, which says that the existing leases after its expiry, it cannot be extended.
That was a policy.
Immediately after expiry, it will be vested to the state government or mineral development, and thereafter they will grant lease by way of fresh auction.
And secondly, my lord, this lease was granted prior to coming into operation of that policy and rule. Therefore, subsequent act cannot govern.
It was granted. That is also covered by the policy. He's saying then it was an existing lease.
It was an existing.
When the policy came into force, the policy was enunciated. Then this was an existing lease. So the policy says, he says, all the rules do not bar. Policy says that no extension. It will, if it vests Mr. Chakraborty, how can you ask the state? Because Mr. Dey is representing the state. Previously, the state was doing it. Now there is a nodal agency. Now, even if they want, they cannot do it. Because at that point of time, when the lease ended, this has come into force.
That is why they are also made a respondent here, my lord.
Yes. So we'll decide this against you, what damages.
My lord, may I be permitted to take leave?
Oh, yes, Mr. If you don't take leave, the state will be suffering in other courts. Yes. The present challenge has been preferred against an order passed in a writ petition, whereby the petitioner's challenge to the refusal of the petitioner/appellant's claim for extension of a mining lease deed was turned down by the respondent authorities. For some next para, learned counsel appearing for the appellant submits that in terms of the then prevalent notification dated May 23, 2017, the successful bidders who have deposited 1/3 of the bid money may be allowed to commence mining operations and lease deed may be executed. Full stop. Clause 2 of the said notification provides that the balance amount of money shall be payable in 3 installments with a gap of maximum of 45 days each from the date of first installment, which shall in no case exceed the lease period or the closure of mining operation. Full stop. In the present case, the balance amount was paid by the appellant within the said period, that is the tenure of the lease, and was duly accepted by issuance of no due certificate by the respondent authority. Please take a seat. Yes. No due certificate by the respondent authority. Full stop. Next para. However, in spite of the same, by an intimation dated September 24, 2019, the additional district magistrate and district land and land reforms officer, Purbo Bardhaman, instructed the concerned block land and land reforms officer to stop challan against the lessee within bracket present appellant bracket closed in the then upcoming season until and unless instruction was given from the end of the additional district magistrate. For some next para, it is contended by the appellant that due to such stop order, for the period between September 2019 and April 2022, April 22, 2022, comma, when the amount was ultimately cleared off by the appellant, comma, the appellant was prevented from conducting mining operations on the leasehold land. Full stop. Next para. Accordingly, comma, the appellant contends that the appellant is entitled to extension of the period of lease for the period which was lost between September 2019 and April 2022 due to no fault of the appellant. For sub next para, learned counsel for the appellant places reliance on clause 5 of the lease deed entered into between the parties in pursuance of the tender, comma, being successful, in which the appellant was granted the mining lease, comma, which is a force majeure, MAJEURE clause. Full stop. Next para, it is submitted that there was no fault on the part of the appellant in the mining work being stopped for the relevant period, and comma, as such, comma, by invocation of the said clause, comma, the period of the delay should be added to the period fixed by the lease. Full stop. Next para, it is further argued by learned counsel for the appellant that the respondent number 2 stroke designated nodal agency only became so designated in the year 2021, comma, by operation of the rules which came into force that year. Full stop. Next para. However, comma, it is pointed out that the lease of the petition of the appellant was executed much earlier, and as such, comma, it is submitted, comma, the said rules should not be applicable. Full stop. Next para. Furthermore, comma, it is argued that the 2021 rules do not bar specifically the extension of the lease period. For the next para, lastly, comma, learned counsel for the appellant argues that section 25 of the Mines and Minerals within bracket Development and Regulation bracket closed Act, comma, 1957, comma, which was in force at the relevant point of time as well, comma, any rent, comma, royalty, comma, tax, comma, fee, or other sum due to the government under the said act or the rules made thereunder, or under the terms and conditions of any reconnaissance permit, comma, prospecting license or mining license, mining lease, may, comma, on a certificate of such officer as may be specified by the state government in this behalf by general or special order, comma, be recovered in the same manner as an arrear of land revenue. Full stop. Next para. Accordingly, comma, it is submitted that the only mode of recovery recognized by statute, if the entire amount payable under the mining lease is not paid, is by way of certificate recovery under the Public Demands Recovery Act. Full stop. Next para. Thus, comma, the modality adopted by the respondent state by stopping the mining work for the relevant period ought to be compensated by extension of the lease by invocation of the force majeure clause in the lease deed. Full stop. Next para. Learned AGP, additional government pleader appearing for the state, controverts such submission and places reliance on clause 2 of the notification dated May 22, 2017, where it is mentioned that the balance amount of bid money, comma, after the payment of the first tranche TRANCHE of 1/3 bid money, comma, shall be payable in 3 installments, comma, with a gap of maximum 45 days each from the date of first installment, comma, which shall in no case exceed the lease period or the closure of mining operation. Full stop. Next para. By placing particular stress on the expression double inverted from the date of first installment double inverted close, comma, it is argued by the state that the first installment is the payment of the bid amount of 1/3, and as such, comma, since the payment by the appellant in the present case was made 3 years thereafter, comma, the timeline stipulated under clause 2 of the notification was flouted, and, comma, as such, comma, the appellant has no right to seek an extension of the lease deed. Full stop. Next para. Learned additional government pleader, comma, as such, comma, contends that the learned single judge was justified in refusing the prayer of the appellant. So next para. Learned counsel appearing for the respondent number 2 stroke designated nodal agency under the 2021 rules points out that under the sand mining policy, within bracket, may it be noted that the present lease pertains to sand mining, bracket closed, comma, which culminated in the 2021 rules, comma, the mining leases existing at that juncture would automatically not be extended further. Full stop. Next para. As such, comma, it is argued that since the uh, mining land has now vested in the nodal agency, comma, even if the state respondent number 1 wanted to extend the lease, comma, law does not permit such extension in any event. Full stop. Next para. Thus, it is argued that the appeal ought to be dismissed. Full stop. Next para. On a careful construction of clause 5 of the lease deed, comma, which is the force majeure clause, comma, we do not find support for the argument advanced by the appellant on such count. Full stop. Next para. A force majeure pertains to a natural calamity such as act of God, comma, war, comma, insurrection, comma, riot, comma, civil commotion, comma, strike, comma, earthquake, comma, tide, comma, storm, comma, tidal wave, comma, flood, comma, lightning, সব কমা দিয়ে কমাটা রিপিট করছি না, lightning, explosion, fire, and other happenings over which the lessee could not reasonably have any control. Full stop. We derive the said meaning from clause 5, that is the force majeure clause in the lease deed itself. Full stop. In the present case, comma, at best it could be argued by the appellant that the stoppage of the mining operation was due to unlawful action on the part of the respondent authorities in violation of the notification dated May 22, 2017, comma, which, comma, though beyond the control of the lessee, comma, does not come within any of the supervening impossibilities or force majeure as contemplated under the force majeure clause. Full stop. Thus, comma, the relief of extension of the lease period, comma, as contemplated in the said clause, comma, could not in any event be given to the appellant. Full stop. Next para. Secondly, comma, it is well settled that the court cannot rewrite a contract between the parties. Full stop. Next para. The appellant clearly entered into the lease deed, mining lease deed, comma, in which it is this clause is of the tender document of the lease, in which, comma, clause 6 stipulates that the balance amount after payment of the 1/3 bid amount, comma, that is the remaining 2/3 of bid money, comma, shall be payable by the lessee. Yes.
Only one interruption, my lord. Rule 21 explanation,
We'll look at
clause D, order passed by the statutory authority. That is a ground for
payable by the lessee in 3 equal installments with a gap of maximum 45 days each from the date of first installment, তারপর double inverted, which has already been paid on 27.06.2017, double inverted close, full stop. Thus, comma, in the said clause of the lease deed between the parties, comma, it was categorically construed that the first installment as contemplated in clause 2 of the 2017 notification would be the payment of the 1/3 amount of initial bid amount. Full stop. Next para. We cannot give benefit of doubt to the appellant, comma, since the sand mining lease was a full-fledged commercial contract and the appellant, comma, being in the mining business, comma, entered into the contract with its eyes wide open. Full stop. Thus, comma, the appellant cannot resile from that position. Full stop. However, comma, a scope of argument remains as to whether the said clause, comma, being contrary to the purport of clause 2 of the notification dated May 22, 2017, the latter having the force of law, could bind the appellant, since there cannot be any estoppel against the statute, stroke law. Full stop. Next para. The language of clause 2 of the notification in question is unambiguous. Full stop. The first installment mentioned therein pertains to the 3 installments of the balance amount payable. Full stop. Thus, the 1/3 bid amount which is initially paid cannot come within the purview of the first installment for the balance amount of the rest 2/3. Full stop. As such, the construction lent to the said provision in the mining lease deed itself, is contrary to the notification. Full stop. Next para. However, in any event, the remedy of the appellant at best lies in a claim for damages which is to be made before a competent civil court of having jurisdiction. Full stop. Next para. Even otherwise, learned counsel for the respondent number 2 is justified that since the entire mining operations and the mining lands have been vested in the said nodal agency at present, after the coming into force of the 2021 Act, there is no scope for the state extending the period of the lease deed or even the court directing the state to do so. Full stop. Next para. Hence, we are of the opinion that the learned single judge was justified in passing the relevant order. Yes, what were you relying on? Rule 21.
On question of extension, your lordships are of the view that court cannot direct for extension. And
D,
there is
D,
no
D.
D. Section 20, Rule 21, explanation D. Any order passed by the competent authority.
Let us see this. Next para. Learned counsel appearing for the appellant also seeks to place reliance on explanation small d within bracket of Rule 21 of the West Bengal Minor Minerals Concession Rules, 2016, to argue that as per the said provision, the authorities are to consider orders passed by any statutory or competent authority to come within the purview of the justification for not terminating the mining lease deed. Full stop. Next para. However, the said provision cannot be imported into the present consideration for the simple reason that the scope of operation of the force majeure clause in the mining lease deed of the appellant stands on a completely different footing than the explanation to Rule 21 within bracket 4. Full stop. Rule 21 within bracket 1 of the 2016 rules contemplates that subject to other conditions mentioned in the rules, where mining operation has not been commenced within a period of 1 year from the date of execution of the lease or is discontinued for the above period continuously after the commencement of such operations, the state government or the lease granting authority shall, after serving notice to the lessee, by an order, declare the mining lease as lapsed and communicate the said order to the lessee. Full stop. Para. Thus, the entire scope of operation of Section 21 is for declaration of the mining lease as lapsed. Full stop. Next para. The explanation to the said rule carves out an exception to the situations where the mining lease would be declared to be lapsed if mining operation is not started or discontinued for a period of more than 1 year. Full stop. Next para. One of the mitigating circumstances for not declaring the mining lease as lapsed in case of such discontinuance of mining operations is orders passed by any statutory or competent authority. Full stop. Next para. However, we, in the present case, are not looking at a situation where the mining lease has been declared to be lapsed. Full stop. The explanation to Rule 21 can only afford grounds for mitigating the circumstances under which a lease deed would be declared as lapsed. Full stop. In the present case, the lease deed was not declared so, and the respondent state accepted the later payment and permitted the continuance of the lease during its entire tenure. Full stop. Next para. The question here is whether such mitigating circumstances can be read into the mining lease deed as a force majeure clause for the purpose of permitting the appellant to seek an extension of the lease deed. Full stop. With utmost respect to the submissions of learned counsel for the appellant, we are unable to agree with such contention of the appellant, since comparison of the said explanation of Rule 21 with the force majeure clause would be akin to a comparison between the proverbial apples and oranges. Full stop. Next para. Whereas Rule 21 operates within the ambit of declaring a mining lease lapsed, the force majeure clause in the mining lease deed provides for an opportunity and a second chance for the time lost in mining operations to be added to the period of the lease. Full stop. Hence, Rule 21 or its explanation does not have any relevant bearing in the present consideration. Full stop. Next para. In view of the above, we are of the opinion that the only remedy which might be available to the appellant would be by way of damages for the stoppage of mining operations by the respondent state during the period between September 2019 and April 2022. Full stop. Next para. Since the said stoppage or the intimation stopping such mining operation was never challenged by the appellant, we, sitting in appeal within the limited scope of the present matter, cannot look into the validity of the same as well. Full stop. Next para. Thus, MAT 1304 of 2025 is disposed of on contest without interfering with the impugned order, but making it clear that nothing in the order of the learned single judge of this court shall prevent the appellant, if the appellant is otherwise so entitled in law, to claim damages for the stoppage of mining operations by the respondent state between the period September 2019 and April 2022 before a competent civil court having jurisdiction in the matter. If such a suit is filed, the civil court shall decide the same independently and in accordance with law, without being unnecessarily influenced by any of the observations made above or in the order impugned before us. Can 2 of 2025 is also disposed of consequentially, no order as to cause certain security. চ্যালেঞ্জ করেন নোটিফিকেশন তখন চ্যালেঞ্জ করলে সেটা সেট করে দেওয়া যাবে পাস ওভার ম্যাটার
the past over matter, my lord.
Yes, বইটা ফেল
What we talk.
Item number 7.
Well, I'm the appellant, my lord. But the lordship is that matter.
Yes, Mr. Datta, we deliberately said that we'll cancel the parter to ensure your appearance. Yes.
No,
Otherwise, you won't be available before the court.
no. No,
Yes.
my lord,
You are still panting. Please take your breath and then start.
no, my lord, I'm all right.
All right, very good. Yes.
My lord, here, my lord, your lordship wanted me to start from the supplementary affidavit on the last occasion. The lordship learned.
Better give a brief for justice.
This is the matter relating to the grant of license to a FPS dealer. That license, the eligibility criteria is that he must be a cooperative society. Now, in the application, he declared this Sijoni, Kandi Sijoni, to be a cooperative society.
Mr.
But
Dotto, which act will you be relying on? Just tell them so that our officers can get the act first.
the act is the
Any act or anything
I can
or rules which they'll in the meantime find out.
they didn't just
Only relied on something on last occasion.
Here,
control order.
Bengal control order.
Control order is annexed probably.
Yes, no, it's not annexed, but I can hand up to you.
Hand it over separately. On the last occasion,
I think it is. It was there.
we'll just check up with it.
Essential Commodities Act is there. One book I find here
Essential
at the top.
Essential Commodities Act.
May I hand over one book?
Control order you have separately.
Yes.
Do you have 2 copies? No.
Well,
But you don't. You won't
I
have a
have
copy
all of the photocopies. I can.
You won't have a copy then. Oh, this book? Yes, we have. Which page of this book? Same book.
2013, sir.
No, it is control order there.
Yes, it's got to 2030. Itu.
Lordship, if your lordship,
Yes,
I just
West Bengal Urban Public Distributor.
No, it's not
Rural.
This is rural. But if I just give you lordship the facts, then
Yes, in the meantime, facts and
here,
figures.
if your lordship,
My lord, 1.7. Page number 1.7.
1.7, no?
West Bengal Public Distribution
Yes, yes,
System
sir.
Maintenance
That's it.
and Control Order 2013.
I can hand up a copy.
No, you find out for us from this book.
কত 1.7 তাই তো
ওকে দিন করে দেবে
বইতে মিলবে না আর একটা কপি নেই আর যশবদের জন্য কপি না আমার কপি
ওরকম ডিজাইন
দুটো কপি আছে দুটো কপি দিয়ে দে তোদের আছে তো দে না
হ্যাঁ এটা করে দেবে থ্যাংক ইউ
লর্ডশিপ
yes sir
now this
please carry on Mr. Dotto that it was to be
briefly my lord I'll go to the controller later my lord.
Later.
The facts are my lord very short and I just this is the if I take your lordship to আমার petitionটা কোথায় আমার কপিটা কোথায় if your lordship takes this will make the position clear if I refer to some pages of the stay petition if your lordship takes my lord page 87-88 of the stay petition this will make the position clear this is the
right Mr. Jadhav yes
lordship kindly have a look to page 87
yes
well this is the inviting this is an advertisement inviting application for grant of license against vacancy at the top your lordship will get
yes
lordship got it at the top this is the vacancy notification this is dated 11th of December 2023 now I just omit 1 and then 1A then 1B is relevant for us I just replace 1 in pursuance of approval of the government in Food and Supplies Department, video order number so and so, Department of Food and Supplies Department, District Magistrate, applications are invited from an individual permanently residing in the Domkal subdivision. Then B is relevant for us. Registered partnership firm, then registered cooperative society.
Mr. Dotto, if you just give us 1 minute, just to recapitulate, this was probably they had declared that they are a registered cooperative society.
Yes.
They were granted this FPS license. Subsequently, it was revoked on the ground that they are registered as a cooperative society under the Societies Registration Act, not a cooperative
society under the
society under the Societies Registration Act, and
Yes,
not under the cooperative society.
That infirmity, the inherent infirmity, my lord, came up pursuant to subsequent scrutiny of the document.
Scrutiny of the document, and you revoked their license.
Yes, license.
Now they have taken also a point that you cannot cancel. If you have to cancel, you have to give a hearing and the provisions. You say no. It's settled that the license issuing authority has the power to revoke also.
Yes,
This is
that
not a cancellation under this
Yes.
provision. You revoke the original license which was granted.
Yes.
So this is your case.
Well, I also relied on Section 21 of the General Clauses Act.
Yes.
Power to grant includes power to rescind. Language is rescind. So that power is there. So until I'll show that. Now, my lord, and then I also submitted that this is an error committed at the end because of the misleading declaration at the threshold that the applicant is a cooperative society, which it is not. So therefore, my lord, this infirmity continued till such time they continued to run the business. But when it subsequent scrutiny, it came to light that it is a society under the Societies Registrations Act. Then, my lord, it was rescinded or revoked.
But they had produced a certificate of registration of societies with you.
Yes,
At that point of
that,
which,
that,
which is
that,
what
that,
they are
that is
saying.
their contention because that document was before you.
That document.
We say that yes, that was our mistake and we have rectified the mistake and that is permissible under the law. I shall be citing one judgment or one sentence that I can do that. So, my lord, basically, my lord,
So you have shown the relevant provision.
I shown relevant provision. I also cited one judgment of 1985 where what is revocation, how it means, the implications, etc. All were.
We'll come to that immediately, Mr. Dotto. But before that, let us come to their declaration, where they
that
made
your
the
lordship
mistake.
kindly have a look to my supplementary affidavit. That's why your lordship said on the previous occasion we will start from the supplementary affidavit.
Yes. Now,
My lordship.
yes.
Because of the time gap, my lord, I also at times, my lord.
No, naturally.
No, my lord, if your lordship, my lord, subtext of my supplementary affidavit, I have given them, they have dealt with it.
Yes.
My lord, page 14. This is from the screenshot of the portal. Neither he can tamper nor anybody can tamper. This is what it is. Lordship kindly sees page 14.
Registered cooperative society.
At the bottom, Kandi Srijoni, the date petitioner.
Yes.
And this is the application number is there. There is a society. Now, my lord, then, my lord, this the date of the application submission of the application is will appear from page 19 at the bottom. At the bottom. Date of submission of application. This is part of that, my lord, the application. At the end, you will find date of application 13th of October 2024. The time is also mentioned here.
13th April 20.
13th April.
Yes.
2024. Now, my lord, then, my lord, the next document that they are relying upon, page 20, and it's at D, Certificate of Registration of Societies under the Societies Registration Act, 1961.
এটা ওরা বলছে যে ছিল অথরিটির কাছে আমি দিয়েছি তাহলে তোমরা এটা দেখলে না এটা যদি ভুল হয় ওদের ভুল ওদের চাই কিন্তু ওটা এটা দিয়ে হচ্ছে পরে করার পরে সবচেয়ে বড় কথা এটা দিয়েছিল কিন্তু সঙ্গে ওটা রেজিস্টার্ড কোঅপারেটিভ সোসাইটি
Yes, sir. Now, my lord, this document they applied as a cooperative society, but the document they disclosed was under the Societies Registration Act. So, my lord, they proceeded on the basis of the application made. But what they have done, this was not scrutinized properly. My lord, that is a mistake on our part, and that was rectified by revoking the license. And that is permissible under the law. My lord, I'll be relying on a judgment that I'll come later on. Lordship, kindly see what has happened thereafter. Now, my lord, this supplementary affidavit, my lord, these next documents, my lord, not very legible in the state petition, so the eligible copies have been supplied by your supplementary affidavit. Nothing else. Now, my lord, the first point is, my lord, the cooperative society is only eligible under the vacancy notification on 2013 control order. They were not eligible to apply for it. So this page 87, if your lordship takes once again, I'll take your lordship to page 88 at the top. At the top. Incomplete application is incomplete applications or applications received after the stipulated date or applications received from ineligible
Should have been summarily applicant.
rejected.
Applicants will be
So
summarily.
this is part of the vacancy notification itself. Now, my lord, my submission is they were ineligible applicants. So they were applicant was liable to be summarily rejected as per the vacancy notification itself issued under the 2013 control order. Now, my lord, lordship kindly
The eligibility criteria given at the top, applicant must fulfill the following.
yes, that's
eligibility.
where I'm coming.
Shall be.
Applicant must fulfill the following eligibility criteria. I placed already, that's why the II is important. Registered partnership firm or registered cooperative society. So
This
they are
is-
not a registered cooperative. This is the eligibility criteria.
And Mr. Shara's argument on the last occasion, because I'm covering so that for my learned brother.
Yes, yes.
His argument was, may I have other arguments also. One argument was at the bottom.
Yes, at the bottom.
Mr. Shara's argument was, if you remember correctly, that following persons shall not be eligible. So in negative language, it's clearly bar is stipulated there. And this criterion, not being registered cooperative society, is not coming under that.
Yes.
So there is no specific bar. Although
Yes.
eligibility criteria says has to be a registered society, but the other conditions where they will not be eligible in negative language, that is the bar.
Restrictions, rather restrictions. It may-
Restrictions bar. His contention is that this doesn't come under the bar. So it's an irregularity at best, and it could be, I mean, glossed over.
So, my lord, my submission would be, my lord, that once, my lord, at the threshold, if something is void, it is the invalid applicant. It cannot be cured by any such malady. Malady, this is at the it is void ab initio, if I may say so.
Yes.
My lord, the authorities were misled by the application. It's a cooperative society in bold letters. And that, my lord, the root of all acts taken by them, including issuance of license. So, my lord, when it came to light or it came to surface, it was revoked. Nothing irregularity, or this is not something irregular. This is illegal. Void ambiguity. This can't be, it is an incurable defect. This is infirm or ineligible applicant. This whatever is there is there. This should have been summarily rejected, but because of certain the error on the part of the authorities, they lost sight of this certificate of under the registration Societies Registration Act. It should have been, but they really they misled the authorities in a way. They were misled. They have not come to this court also with clean hands. I must say that. That you and the coordinated order is short of only one sentence. The appeal is allowed, writ petition is dismissed. Lordship kindly sees the coordinated order. That's part of it is there.
Coordinate bench order was on what?
Yes, in this matter, the Lordship has I placed the judgment order to
No, in a similar matter for some other person.
In this matter,
Interim order.
interim order. Interim order only, that's what I say, short of only one sentence. Appeal is allowed, writ petition is dismissed. This, Lordship, kindly have a look to that, because that will,
Appeal allowed.
Appeal allowed.
thou said, thou ordered.
Then nothing.
Appeal allowed, then what are you hearing now?
No. I said, Lordship, Lordship kindly sees.
It's your appeal.
He is my appeal.
Allowed.
Allowed? Which order?
No. Why are you saying this? All this?
I
You-
have not said.
You said appeal allowed.
I said short of only one sentence.
Short of that, acha.
I said the order is short of only one sentence. May I read for your Lordship this order?
Amari order. Rajshekhar.
I said short of only.
Short of that. We have misunderstood.
I also.
No, that it
We
is-
misled you to misunderstand.
Yes. Lordship,
Yes,
the Lordship has
appears to have been actively induced by the misrepresentation.
yes.
Para 7 of the judge.
Yes.
Of that.
So I placed your last occasion.
Yes.
Honorable Justice. Not there, Lordship kindly sees it was It was about to be dismissed, allowed, and the referendum was about to be dismissed. On that, at that point of time, there was a prayer on behalf of my learned brother. This on the other side. That's why the matter was adjourned. Lordship, see the tenor of the order. It is very clear. I don't have to repeat what I am arguing for this. It is all there. And my lord, this he relied on the section 24. This is not section. Para 24 of the control order should be required, should be followed, because the natural justice principles are embodied there. That once
cancellation.
For cancellation, but then it is not a case of cancellation; it's a case of revocation. It stands on a different footing altogether. So, my lord, this 2000, what is it? 2000, my lord, only your lordship knows. Even then, my lord,
No, please say.
well, this to rectify an error. Well, this is AIR 2009 Supreme Court, page 34, paragraph 24. Well, one sentence I read.
Para 94.
Para 24.
24.
Towards the end. This was last sentence. It is well settled that a bona fide mistake does not confer any right to any party, and it can be corrected. I think this sentence will suffice. This is AIR 2009 Supreme Court, page 34, paragraph 24. I think towards the middle end of page. Yes, end of this
Second
one
last
sentence.
line.
Yes,
Yes.
second last line. It is well settled that a bona fide mistake does not confer any right to any party, and it can be corrected. That's what exactly has been done in this case for revocation of this order. And what I cited was a 1985 judgment of the Supreme Court, 85 judgment of Down, where one of the revocation has been 85 Supreme Court. Lordship has I handed up my lord.
The hand over should be here. We'll just check.
This judgment is there on record. Paragraph police
Must be there. Yes, yes. 85 Supreme Court is there. Folder আছে দেখো।
Yes, yes.
ওরাও জাজমেন্ট সাইড করেছিল দেবগতিদাও করেছিল ঠিক আছে
My lord, yes, my lord, the 85 Supreme Court 697, AIR 1985 Supreme Court 69, I cited already.
Yes, yes.
Paragraphs 8 and 9.
8 and 9 টা দেখে ওখানে আছে রিভোক করতে পারে।
Paragraphs 8 and 9. 8 I read for your lordship's my lord once again.
Yes.
This list to examine the tenability of the submission of Mr. Jetmalani as to the true meaning of the word revocation. Revoke is the verb and revocation is its noun. These words have no statutory definition and therefore would take the common sense meaning available for these words. Black's Law Dictionary gives the meaning of the word revoke to be the recall of some authority or thing granted, or a destroying or making void of some deed that had existence until the act of the revocation made it void. Wharton's Law Lexicon gives the meaning to be the undoing of a thing granted or a destroying or making void of some deed that had existence until the act of revocation made it void. Shorter Oxford Dictionary gives the meaning of the word revocation to be the action of recall of persons, a call or summons to return, the action of rescinding or annulling, withdrawing. The meaning of the word revoke has been given to as to recall, bring back, to restore, to retract, to withdraw, recant, to take back to oneself. The true meaning of the verb revoke and its noun therefore seem to signify that revocation is the process of recall of what has been done. According to the Webster Third International Law Dictionary, the word means an act of recalling or calling back, the act by which one having the right annuls something previously done. According to the Corpus Juris Secundum 52 edition, 70 volume, the word revoke carries with it the idea of cancellation by the same power which originally acted, and not to setting aside of an original order by higher forum of power or jurisdiction. It does not mean repudiation. Very clear. Then, my lord, 9 is, my lord, this power conferred under clauses, my lord,
Yes, will just come.
My lord,
Para 9, yes.
yes, my lord. Para 9, my lord. Judgment কোথায় গেল?
As you were saying, General
Yes.
Clauses Act, Section 21.
My lord, this আরে ওই judgment কোথায় গেল? Excuse my lordship, give a minute.
Yes.
But, এই যে, sorry, my lordship, I was placing, about to place paragraph 9 of that 85 judgment.
Yes.
Well, I just read out for your lordships. My lord, power conferred under clauses A and B of subsections 1 of section 11. This is one of the FERA Act, section of FERA Act, is in fact extension of the power recognized under section 21 of the General Clauses Act. And while under the General Clauses Act, the power is exercisable by the authority making the order, the named authorities under clauses A and B of section 11(1) of the Act are also entitled to exercise the power of revocation. It says that similar to section 21 power in the FERA Act. When the High Court exercises jurisdiction under Article 226 of the Constitution, it does not make an order of revocation. By issuing a high prerogative writ like habeas corpus or certiorari, it quashes the order impugned before it, and by declaring the order to be void and striking down the same, it nullifies the order. The ultimate effect of cancellation of an order by revocation, they are taking a point that initially it was cancellation, but cancellation by way of revocation. Here, the Supreme Court also says that the ultimate effect of cancellation of an order by revocation and quashing of the same in excess of the high prerogative jurisdiction vested in the High Court may be the same, but the manner in which the situation is obtained is patently different. And while one process is covered by section 11(1) of the Act, the order is not known to the statute and is exercised by an authority beyond the purview of subsection 1 of section 11 of the Act. It is therefore our clear opinion that in a situation where the order of detention has been quashed by the High Court, such is not applicable, and the detainee authority is not entitled to make another order under section 3 of the Act. First of all, in paragraph 8, what is revocation? The verb and the noun, everything has been explained. Yes. And in paragraph 9 of this judgment, my lord, it has been, my lord, that the power exercised by the authority making the order, it is very clear. Yes, the ultimate effect of cancellation of an order by revocation and quashing of the same in excess of the high prerogative vested in the High Court may be the same, but the manner in which the situation is obtained is patently different. And while one process is covered by section 11 Act, the order is not known to the statute and is exercised by an authority beyond the purview of section 1. So, my lord, here, my lord, is very clear. Supreme Court is very clear. This is a very, this is, my lord, it's a very 85 judgment, but this on this point of revocation is very clear. There is no ambiguity in it. Now, my lord, this section 21, if you I just cited earlier.
Yes, General Clauses Act.
General Clauses Act.
Although that refers to notifications, orders, rules, or bylaws, so you may say this is an order in that sense.
Yes. Power to issue to include power to add to, amend, or vary or rescind notifications, orders, rules, or bylaws. Everything is included here. Whereby any central act or regulation or power to issue notification, orders, rules, or bylaws is conferred, then the power includes a power exercisable in the like manner and subject to the like sanction and conditions, if any, to add to, amend, vary, or rescind any notification, orders, rules, or bylaws so issued. Similar the this is the.
But this is on a slightly different footing, Mr. Datta, because here rules, notifications, bylaws, or orders, when it is issued, the policy of the state cannot be dictated by the court. That will remain the same.
Yes,
it may subsequently rescind that.
Yes.
But in this case, Mr. Shah has claimed valuable rights had accrued in his favor by grant of the license. So that is one of the points you'll have to also meet, because Section 21 is not directly applicable, but the principle may be.
Yes,
for the
I agree. I borrowed out the last observations.
For the proposition that the issuing authority has the right to revoke it also. For that right.
Well, the answer is very simple. Well, I just address the last one that.
Yes.
Well, the applicant was ineligible That goes to the root of the matter.
Ab initio.
Ab initio. It's a void ab initio. He's an ineligible applicant. No manner of right accrues in favor of an ineligible applicant whose application was liable to be dismissed at the threshold, as per the vacancy notification itself.
Yes, we can draw inspiration probably from the recent education judgments in the
Yes.
education matters.
My lord, if it is bad at the threshold, it is bad for all time to come. It is an incurable defect. It cannot be cured by any thing or act done subsequently.
Even if you were negligent, your negligence cannot confer a right on them.
Yes,
which
that's
they are
what I
not
cited that judgment.
that judgment.
It does not confer any right. And so, my lord, no right accrues from an ineligible applicant. And, my lord, it is an error on the part of the authority which issued the license in its favor. And that was rectified or by way of cancelled by way of revocation. So it is the case of revocation, not cancellation at all. If they are trying to make out a case of cancellation,
Yes.
attracting Rule 24, para 24 of the control order. But that is applicable in cancellation. So it is not a case of cancellation at all. It's a case of revocation. There lies the difference. Its dichotomy is there.
No provision specifically for revocation is there in this control order. Revocation, there is no specific power
No.
But you say implicitly, inherently, it is there in the
Inherently,
issuing
the
authority,
power is inherent.
for which you rely on this judgment.
Yes. In judgment and section 21, the inspiration, the lordship is the guiding principle, my lord.
Yes, section 21.
My lord, this is the inherent power. And, my lord, this, if your lordship, I take your lordship to supplement every few paragraphs and to show how they have dealt with it. Huh? No.
1.17.
My lord, what I am submitting, it is all there in the supplement affidavit. They have dealt with it.
Yes.
My lord, lordship text page 3. On a paragraph 2, I placed this from the vacancy notification. It is also there. And these are not denied. These are not denied in the exception they have filed to this affidavit. But these are all from the vacancy notification itself. Page 3, paragraph 2.
Yes.
Our supplementary affidavit.
So that is the vacancy notification itself.
Yes. And then, my lord, the paragraph 3 is important.
3 have they denied?
No.
This is eligibility criteria.
No. How they have dealt with it, I just wrote
No. Where you have stated that the portal has been referred to, where is that paragraph?
Portal has been
It
referred
is
to.
evident from the screenshot, para 8.
Yes.
Now, what is their exception to
There
this
it's-
para 8? Also,
আমাদেরটা ওদেরটা এক্সেপশনটা কোথায়? এই তো এক্সেপশন। My lord, this lordship, my lord, there is no denial as such of any of the statements.
deny and dispute that my application ought to have been rejected.
These are vague denial. It's vague denial.
They also say my application ought to have been rejected on the ground of mentioning misleading statement in the application. Say that it ought to have been rejected then, not now.
Yes, that's what I said. There lies the mistake or error on the part of the authority.
They rather admit that this was there in the portal.
Yes, they admit it. They admit it was there. So there is no, as such, there is no denial.
Their argument is on a different footing, actually.
Yes.
Mr. Sara's argument is on a different footing. You didn't have the power and
You didn't exercise.
you should
Now
have
we come to
rejected
that.
then. Now you cannot come up and say.
Yes, but my lord, lordship kindly sees, my lord, now.
No, that you have made. That argument you have made.
I have already made, my lord.
Yes.
I don't want to repeat it, my lord. And my lord, this আর কি দেখো বাদ তো কিছু বলার নেই।
Since we are at it, Mr. Shahara also cited a judgment, although you are formally not in reply. But since we are covering things, this judgment, a division bench judgment, Justice Subrot Taluka unreported judgment, was a copy given to you? Honai Food Marketing. At that point of time, probably a copy was given to you.
আনরিপোর্টেড জাজমেন্ট দিয়েছিল বলছে, ও দিয়েছিল বলছে।
If you have a copy, Mr. Shahara,
Yes, I have got a copy.
maybe that you gave on the.
No, I've got a copy.
Yes.
I'm sorry, my lord.
No.
I missed it. No, my lord. You know, this judgment of a coordinate bench of Justice Subrata Talukdar.
Yes. Yes.
এটা তো আমি এখন রিপ্লাইতে
Page 7, clause J probably, para J probably, Mr. Harry, because that's marked in my code. J and K.
J and K, my lord, yes, my lord, I just
Kultuli.
well, this is a judgment dated 26th of August 2021.
Yes.
And my lord, the vacancy notification, I think, my lord, the vacancy notification of 2023. The vacancy on page 87. Page 87. This 11th of December 2023 is the vacancy notification. So after this judgment of 26th August 2021 of the coordinate bench, well, the vacancy notification was issued. Now, my lord,
under that, it was held that definition of a distributorship does not exclude the appellant stroke company from applying. There it was a company. So clause 2 does not exclude that argument in support of the argument of Mr. Shara that clause 2 here also, I mean, does not exclude those relative and employee and those clauses, the last clauses.
I don't think one of the submissions that I have advanced before lordship here, those submissions were made before that the coordinate bench. I don't think so. That is, prima facie it appears to be so. I missed it. I should have.
And in K, it was stated that no defects connected to the eligibility particulars furnished by the appellant were found. But here you say that there is a defect.
The factual I find, there is not fact situation is not similar. I believe fact situation is that is also a distinguishing. Fact situation is different. I believe. This is a tender matter granting MR distributorship to an ambitious legal exercise. It's a tender matter, my lord. Well, the fact situation is different. Prima facie it appears to be so.
Your lordship, there was a company, and a question arises as to whether natural persons only to natural persons.
Yes, the natural and artificial persons in a tender relating to grant of MR dealers distributorship. It is MR distributor, it's a MR dealership. Distributorship is different from dealership.
That the language was group of individuals as an entity or acting as an entity. So question was whether that applied to natural
and the group of entity as limited as eliminating the appellant's company. It is equally incomprehensible that the construction of the expression of a group of individuals, the facts are entirely different, madam.
Here the question is a bit different, probably subject to what Mr. Shara will say.
Yes, madam. Definitely, madam. Different. The facts is different.
Categorically stated cooperative registered social.
Yes.
Registered cooperative.
It is not relevant, madam. I don't think this has this will be any assistance to lordship, madam. I say, madam, there is no application because the fact is different. This
all right.
It's not relevant, madam. Let him, madam, finish his
message and reply. So we'll hear Mr. Shara, then Mr. Yes. Yes, Mr.
And I shall start from the last query of the court.
Yes.
That whether the under control order 2024, there is a provision for revocation or not. My learned senior friend submitted no. I say yes. I shall show to your lordship. Not now. I shall show. But that power has been given subsequent to my cancellation. That's my case.
Then it is we would have.
I shall come. The 3 points mainly argued by learned senior friend: suppression of facts, revocation is permissible under law. If any mistake is there, that can be rectified at any time. There is no bar. Then interim order of the Honorable Division Bench has been placed before Lordship. This is not an issue. I don't think I have to argue. And the last, revocation, a person, if enjoys the power to grant, he has also the power to revocation. Judgment has been relied on. In all 3 judgments, my learned senior friend shown, one line is there. having the right to revocation. I shall show to your lordship all three judgments.
Two judgments were cited.
Two judgments. Or has been vested to revocation. So a person who is granting, he has the right to revoke also. Having power. That same simple line is there. I shall show to your lordship. Now, your lordship, kindly allow me to make my submission according to my way. Just 2-3 documents.
Absolutely.
Your lordship, kindly come to the order impugned at page 94. One paragraph I shall read to your lordship. Start from page 94. State operative portion at page 102.
If Mr. Shara, if you can please refer to the internal pages, we'll look from the memo.
Internal page, my lord, kindly come to page 7, 8. 9. Internal page 9.
9, we are there. 9, yes.
Internal page 9.
Hmm.
The last part, second paragraph, in my opinion.
Yes.
In my opinion, the concerned subdivisional controller has to take the decision according to the provisions of law. It may appear that the license was issued not following the entire terms of vacancy notification. But once the license was issued, the status of the petitioner is now licensee but not an applicant. Under the above observation, the impugned order passed by the concerned authority dated 24th of March 2025, this is a revocation order, is hereby quashed. The concerned authority is directed to reinstate the petitioner with immediate effect as licensee and allow him to continue with the license according to the procedure established in law. Next paragraph is very important. I make it clear that the finding of the court shall not debar the authority concerned to proceed against the present petitioner for termination of license according to the procedure established in the West Bengal Controller Swans.
That is a different provision, cancellation, on those grounds. That in any event they would have.
Now, your lordship, kindly come to page 82. The hearing notice.
Here you are hard.
Yes. I have been heard.
Ah.
Which manner I shall show to you, lordship.
Yes.
Page 82, dated 4th of March 2025.
Yes.
Addressing to my client by the subdivisional controller, subject personal hearing on the matter, your applicant status. Take note of applicant status.
Which the learned single judge said he was no longer an applicant, become a
Applicant status. In connection with the above noted subject, you are hereby requested to appear before the undersigned at the office chamber on 11th March 2025 at 2 p.m. for a personal hearing. You are also requested to bring with all corroborative documents in support of your candidature. But nothing has been disclosed. What is the charge? What is the complaint against me? No show cause to submit my reply, straightway hearing notice, only intimating these things. Now, your lordship, kindly come to page 85. The order impugned. But from second paragraph, I am reading page 85, 24th of March 2025, and whereas.
Yes.
And whereas Kandri Sijuni was accorded approval to get fair price shop license on 17 September 2024, after being recommended by the district level fair price shop selection committee. Take note of district level shop selection committee, 23rd August 2021, this is the higher authority. And whereas Kandri Sijuni was issued fair price shop license on 9th January 2025, kindly take note of. Rejection is mailed 24th March and this is 9th January, bearing license number 20. And whereas on further scrutiny, it revealed that Kandri Sijuni is not a cooperative society registered under the West Bengal So-and-so. Further scrutiny. And whereas Kamirul Islam Secretary, Office Bearer So-and-so was given an opportunity of personal hearing, that's my client, for submission of requisite documents as registered cooperative society. But he could not produce cooperative registration certificate. This is not our case also. I am never saying that I am the cooperative society. As such, the fair price license issued to Kandri Sijuni is maintainable and liable to be cancelled. Therefore, in terms of clause 11 Roman 4 part 5 of vacancy notification dated so-and-so, the license issued to Kandri Sijuni bearing number so-and-so is hereby revoked with immediate effect. Now, kindly come to 11 Roman 4 part 5 at my lord page 87. Start from page 87, the vacancy notice. Kindly come to my lord part 5, page 90.
Yes.
But other terms and conditions, your lordship need not go through the term. Kindly come to my lord. Subparagraph Roman 4. Any suppression of facts, information or incorporation, providing of wrong information in the application from attached documents will be considered as a good and justifiable reason for disqualification for a candidate. Kindly take pause for a moment. Disqualification of the candidate or rejection of application and taking appropriate legal action. So two power is there: cancellation of candidature and rejection of application for grant of license. Applicant, application, not license, not licensee.
At that stage, you had not become the license.
I become licensee.
At that stage, you had not. At the stage of the application, you were an applicant.
No. So
obviously,
this clause specifically provides only in respect of application during pendency of the selection process. You may threshold reject the application or candidature of the applicant, not the licensee or the license holder.
All right.
Now kindly come to my lord, page 86 once again, page 86. But I have shown to your lordship, this has been issued by the Food and Subdivisional Controller Domcall. And this is a license also issued another registered society, registered another society registration act by the same subdivisional controller. And kindly see the date of issue, 24th February 2024, name Malda or Murshidabad Topshil Adibashi Gramin Samiti. License valued up to last line of the document, left hand side, 31st of February 2026. Issued on 24th February 2024. This is part and parcel of my writ petition. And another document I have also annexed in my writ petition. So far their registration number is concerned, this Murshidabad Topshil Adibashi Samiti.
They are not a cooperative society.
They are not a cooperative. They are a registered under the register of cooperative. They are not denying also. State is also not denying.
Society's registration act, like you.
Society registration act. It is not the case of the state, not this is a false statement or false document. They have annexed the document showing that this is also registered under the Society Registration Act.
But can you claim a negative equality?
No, I shall not. I shall say, since it is after granting license, you cannot cancel at that material point of time. This power has been vested subsequently, which I started my argument. They have rightly done it. They have rightly done it. The division bench order also. It is permissible because there is the bar. Who have been barred? That has been mentioned.
That last clause, which you argued on.
So rightly they have granted license to this society and also to me. Now you will also kindly take up their supplementary evidence. That is affirmed in the month of August.
Yes.
Supplementary evidence.
Yes.
29th of August 2025. Right? 29th of last day they have filed it.
29th August.
29th.
Your lordship has just seen the supplementary affidavit, our copies.
Mixed up somehow.
It happens.
It happens to me regularly. It happens to all of us regularly.
Yes.
In chamber. No, no, ठीक है chamber is to submit it. Yes. Found. Lost and found.
This is affirmed by the state.
Yes.
Kindly come to page 20. This is the registration certificate of that Malda Murshidabad Topshil Adibashi Gramin Samiti annexed by the state.
Oh, this is not yours. This is that other entity.
Yes. No. In my writ petition, I have annexed two documents showing that the same subdivision.
Understood. This is not Kandis region. This is of that society.
That's right. But to show that this is also registered under the Society Registration Act.
Yes.
Well, just pausing for this was not very legible in our copies. So legible copies have been supplied.
Oh, acha. Not that you have relied on. Very good.
Not denying.
but not denied.
Not denied. Mala, that is there. Now, Your Lordship, kindly take up our reply to this supplementary exception.
আপনার সামনে দেখছি
This is that.
Yes.
Your Lordship, Mala, kindly come to page 5. But this is not legible. I'm handing over the legible copy. This is inquiry report conducted by the inquiry.
Legible, Mr. Shah. Legible.
Better copy.
No, we'll be confused because you have marked this.
Yes. Well, at first, Your Lordship, kindly see this has been inquired by the inquiring personnel after submission of the application by holding spot inquiry. What is the area of the godown, shop room?
This is regarding yours.
Mine. And what I have supplied, what was the document annexed in my application, that all have been disclosed in the inquiry report.
This was prior to grant of the license.
Absolutely. All applicants to be submitted, then inquiry shall be conducted by the inquiring personnel.
Yes.
By going to the spot to measurement the godown, shop room.
Right.
Then bank balance, everything. Kindly take note of date of inquiry 15th May 2024. Much prior to grant of my license. My license has been granted. Certainly, my lord, on satisfaction, they have granted me license after inquiry. But kindly take note of date of inquiry, then turn the page.
9/1/2025 লাইসেন্স
9 January 25 license has been granted. Serial number 32. This is their recording. Nature of applicant, registered partnership firm, so and so. Answer, recording by the inquiring officer, register of societies. Suppression of facts according to them. I got the license. In the month of January, license has been granted. It has been conducted inquiry on May 2024. Then kindly come to the next page, serial number 37. Whether the organization is registered under relevant act, mention registration number so-and-so. Registration number so-and-so, register of firms, societies, trading, corporate, West Bengal. Suppression of facts. The main submission of my learned senior friend. They have inquired, they have perused all documents.
Yes.
Kindly turn to my lord, serial number 50. Whether the applicant has submitted all documents, applicant submitted all documents as per checklist. These are the documents which I have supplied. I shall show to your lordship. 51.
The problem of the present regime is probably that you have to satisfy several times. Earlier you had to satisfy, but now you have to satisfy several times, several phases.
Then all 51 comments. Applicant submitted all the requisite documents as per the existing government order in favor of getting license. But these documents I have supplied, rather my lord, uploaded along with my application.
Fully considered.
Yes.
That is
fully considered. Now kindly come to my lord. Once again, come back to my repetition, page 38. Now, these are the documents which I have annexed with my application.
That is admitted. This was the document.
This registration certificate.
Your registration certificate.
Yes.
Under society.
Right. Page 38 and 39.
And they also say in the report this corroborates the register of firms.
Yes.
It was.
Now, so far the suppression of facts is concerned, possibly I have not suppressed anything. Much before grant of license, they inquired into.
I think that portal you had only stated that registered cooperative society.
Absolutely not.
Absolutely not.
Absolutely not.
You have not denied in your exception.
There is no endorsement, nothing.
See your exception? That's why we asked Mr. Datta and we looked into the exception.
Yes.
That is you take up para 8 of the supplementary, Mr. Shahara, and para 10 probably of the exception. Para 7. Exception para 7. 8 says it is evident from the screenshot of the subject application that application type has been clearly mentioned as registered cooperative society. In this connection stated that the details of the respondent have been filled up online in the portal. You deal with that in para 7 of your exception. I deny and dispute all the allegations. That's an evasion.
Rejected on the ground of mentioning at the threshold. Had there
Rather you say
my
that
content-
I deny and
Yes,
dispute her.
Yes.
I further say that my application ought to have been rejected
Had
on
I
the ground of.
mentioned cooperative society, it should have been rejected, my lord, on the
So
spot.
admit that it ought to have been rejected.
What
So
I'm
therefore
saying,
this
my
was
lord,
there.
What I'm saying,
On oath.
I have annexed the documents of Society Registration Act. And had I disclosed something else in my application, my contention is that paragraph 7, it should have been rejected at the threshold.
Right.
I have annexed all
Therefore, you
documents.
don't deny that this document was there in the portal. That is not denied here.
My deny and dispute is there. Next to
I deny, dispute everything.
Deny, next two lines says, had I given any false information in my application, that should have been tallied with my documents which I have annexed in my application. And threshold, that application should have been rejected.
You say only this, I deny and dispute all the allegations.
Next,
I further say that my application ought to have been rejected on the ground of mentioning
ground.
misleading statement.
by giving false information.
Next is a different ground. That license has been cancelled without due process. That is your case. The next case.
Yes, my
It
lord.
has been cancelled in effect.
Yes.
That is also your case, definitely.
So, my lord, inquiry.
So you say not that you suppressed, only apart from that one portal entry advised.
All documents.
Everything, and they inquired, and in their inquiry report also it's clearly mentioned that where they inquired, registered, and now they cannot do this.
Absolutely. But so the next question arises whether it is permissible or not after granting license,
Yes.
invoking the provision of advertisement. Whether this invocation of power as vested to the state through a vacancy notification
Yes.
can be used in respect of a dealer who has already granted license. The state says no. Whatever argument on advanced on behalf of the learned HON'BLE pleader, this is not the case of the state. But take up these notifications.
What notification? This was before the writ court. This was
No.
Writ court has considered this point. Writ court has considered this point.
this notification has been
No,
considered.
this has not been referred to.
Don't
This
let
is
me say.
September 25 notification. September 25.
Yes. Why this has been
This is
arised on
subsequent.
only appeal. The single
The 25 is subsequent notification.
absolutely the power has been given.
Oh, you say revocation?
Yes.
Acha, very well, hand over.
Power has been given, only these. That was not recorded before the learned single judge because learned single proceeded on the basis of this. Kindly take note of 12 September 2025. Whereas it has been considered necessary amendment the West Bengal targeted public distribution control order. My license has been granted under 2024 control order. In manner herein appealed. Now, therefore, in exercise of the power conferred by Section 3 and Section 5 the Essential Commodities Act, the governor is pleased to hereby make with an immediate effect the following amendment in the said control order, namely, after clause 14, I shall read my clause 14. In any case, before or after the issuance of offer letter, grant of license, if it is found that the approved candidate or dealer, as the case may be, was ineligible for license on the following or other grounds such as submitted false and fabricated documents, suppressed material facts, these, kindly turn the page.
No, but Mr. Shahara, was you granted license under this control order?
Yes, kindly turn to my
You
license.
are granted a license?
No.
No, the vacancy notification was in 2023.
25.
Your vacancy notification?
Kindly come to license, my straight away. Kindly come to my license. That
Yes.
is my license.
Yes.
License pistol. Just a minute. 45.
Vacancy notification is of 11th December 2023.
Yes.
Page 87.
License. 2013 was that. Then kindly come to my license, page 45. First line. West Bengal targeted public distribution system maintenance and power 2024. So I am governing after granting my license in terms of this control order, which has been amended on 12 September 2025, which suggests that if there is any suppression or misrepresentation, that power is vested to the other authority. I shall show. Kindly read my letter, the second paragraph. by misrepresentation of facts for which the case made out by the state, misrepresentation. The candidate afterwards found to be ineligible. As the case may be, the district level fair price sub-selection committee or the director of rationing in case of Kolkata. In case of Kolkata, director, in rural areas, district level sub-selection committee shall have the power to withdraw or cancel the recommendation in case of any of the aforesaid grounds, notwithstanding anything contained. The director shall have the power to revoke the approval. Kindly take note of revocation part. This is the first
So
time.
we understand. You say that this power was subsequently introduced,
Absolutely.
but therefore by specific implication it was not there when.
Absolutely.
So therefore they could not.
So
This power was conferred later.
A notification has required to be issued since no power has been vested to the licensing authority to revoke license for suppression of material facts by obtaining license by suppression of material facts.
So and you say by publication of this later notification, it was made more clearer that that power was not there.
Absolutely.
That is your
absolutely my case. So power has been vested only after this. And that too, my lord, this power has been given to two separate authorities. I have shown to your lordship my recommendation by the district level fair price sub-selection committee. So
but this authority has also been given the power. The
no. That's what
license issuing authority has not been given.
Not given. That's my second issue. The cancellation letter says your application has been approved by the district level sub-selection committee. I have shown to your lordship.
So issued by whom?
Licensing authority.
Licensing authority has also been given power.
No, that's the issue. Approving authority has been granted the power. Kindly read my lord Roman 5.
Two authorities were given.
One is the director in respect of Calcutta. So far we are concerned, rural areas, only district level sub-selection committee, comprising of the district magistrate, who is the chairman of the committee.
Is it referred to in the learned single judge's order?
Not necessary, because learned single judge considered that there is no power. You have to proceed on the basis of the 2000 control order, statutory control order. Because this is a cancellation. So I have need not to.
Yes, this is a notification. It's a public record. So we'll hear Mr. Dotto on his refutation of this.
You will have once again power vested.
No, power, you say that it's not we now understand. Yes.
District level fair price sub-selection committee in respect of rural areas. And kindly see, my lord.
That has to be communicated to the licensing authority, and they will communicate only.
Yes. No. Power,
Oh, no,
power
but
to revoke the approval granted on any of the appropriate accounts on convolution of the state to the licensing authority. So they will revoke it and shall intimate it to the licensing authority, that is the subdivisional controller. The licensing authority shall revoke the offer letter license issued as per approval and recommendation of the district level fair price sub-selection committee. Because they have recommended, they have approved my candidature. Now kindly take 1 second, my lord, page 82, my license, my cancellation order, page 85, sorry, 85. Second paragraph. And whereas Kandi Sichoni was accorded approval by the fair price shop license also after being recommended by the district level fair price shop selection committee. So this power has been vested to the authority who has approved and recommended my name to revoke my license if anything found subsequent to grant of license. Prior to this notification, there was no power vested even to the district level sub-selection committee to revoke my license after granting license to me. There was only provision that you can cancel the candidature or the application.
This is the subdivisional controller food and supplies.
Is the licensing authority.
Licensing authority.
Who has cancelled straightway without any approval, without any sanction. But I say, even at that material point of time, district level, no power.
Even the district
This is
authority.
not a case of retrospective perspective also.
No.
Because this is not, I can understood, my lord, cancellation May, April circular. By taking retrospective effect when the application was made, this is a separate case. In this case, there was no existence. This notification was not see the light of the day on that day. So, in any manner, subdivisional controller cannot cancel the license. His only option to initiate proceedings against me under 2024 control order.
Mr. Shara, is the 2024 control order in this book?
Yes, I am handing over to your lordship.
No, even.
Not in this book. I'm
No, pre-amendment. 2024 control. Yes.
But kindly come to clause 14, which has been.
Yes.
Can you take note of clause 14?
2024
Targeted first, my lord. Page 14. At page, my lord, 19.
Yes.
Issue of license. But this is an amendment 14A. The notification.
Yes, we check that.
Last page of the
14 has to be seen.
So, my lord, what it says, subject to clause 10 of this order, the licensing authority may grant provisional license to the approved candidate. Organization who has complied with the so-and-so, the license shall be issued in Form 1 so-and-so. Then, my lord, notification says it would be added after clause 14, at 14A. So, this relates to licensee. The moment I grant a license, I cover with 14. 14 never says you have the power to revocation on the day you have allegedly revoked my license. There is no statutory term of revocation on the date of revocation of my license. It simplifies only so far the provisions of vacancy notification is concerned.
Very good. We understand. Yes.
I don't think, my lord, there is any need to rely upon judgment so far the retrospective perspective is concerned.
No, no question.
Because this is not
This
a
is not
case.
retrospective.
That was not in there.
That Mr. Dutt will not argue.
So, my lord, my last submission would
Retrospective will
be
not. But why did you refer to this division bench judgment on the last occasion? Are you still
company that I have lordship just go through.
those paragraphs?
Those paragraphs that it says at that material point of time,
individuals and entities.
Company was not barred.
Specifically not there.
Even in the inclusion list. Who can apply? There was no mentioning of company. Who cannot apply? There was no mentioning of company. But today, your lordship will find there is a specific provision that company cannot apply. Kindly take note of, my lord, this control order.
That is why you cited the later portion of that.
Who cannot apply? The definition clause. Not definition clause.
Non-eligibility clause, rather.
Yes.
Page 17.
Page 17 of the book.
Page 16 and 17.
Page 88 of the writ petition also, it's in the vacancy notification in your case.
Yes.
It's
Yes.
incorporated.
Yes.
Vacancy notification
It's marked there also.
Yes. And subsequent to 24 control order, the company is not permissible.
It's a replica of this program.
Yes. That judgment was delivered prior to this amendment, where company was not been barred. Now company has been barred.
Was that
clause 12?
Yes.
Clause 12.
Corporation or company?
Yes. So kindly take note. Judgment, division bench says
every time a judgment is passed, this some amendment
came into force.
Obviously,
so there is a requirement to specify who is not eligible to participate. Division bench says company has never been mentioned, so that does come within the zone of eligible candidate. Now they have changed. My case is that in the notification there was no mandate that a firm registered under register of cooperative societies is not eligible to apply.
But then you have to come under any of these provisions, because the judgment of justice, that division bench, was that individual or group of entities.
Now that's true. It has been
Came
followed
within
last
group of
occasion also. That
group of entities. Company was not specifically excluded.
I am saying, I am a society.
But you don't come within any group of entities, is not there into
not there. It has been amended subsequently.
Yes.
That's
an individual permanently residing in Domkol, that obviously has to refer to a natural person.
Basic principle which has been followed on last occasion from your lordship. The society registered under the Society Registration Act.
You have to come within any of these.
These are profitable. It has been followed from your lordship. The difference between a cooperative society and a society registered under the Society Registration Act. Just take note of company like that. Company was a profitable. But in terms of the division bench judgment, they have been allowed to participate.
No, the ratio of the division bench was that they came
Group of individuals. Group of individuals. But this is also group of individuals.
but group of individual is no longer there now. In this, if you come to page 88,
Now it has been. Now
therefore
it has
that
been
ratio
now
cannot
it has
be,
been withdrawn.
you
Now
cannot
only
draw
individual.
inspiration from that.
Now individual. But I only want to show from this judgment that person who has not been included. Now, Your Lordship, kindly take note of. Group of individual is not there. Even then, there is a provision, company's part. Take note of. Reverse principle. Now,
The
today,
principle was that there are certain persons who are eligible. They are defined in broad terms, and certain persons who are not eligible for the screening. Companies not specifically excluded there. Therefore, we fall back upon the eligibility, and division bench held that
group of
among those group of individual or entities that covers companies. But here there is nothing to cover. Even if we say that company is barred or not barred, you as a registered corporate, registered society, ordinary registered society, you are not covered by any of. There is no group of entity concept now.
if that is so,
Then the entire ratio has to be taken as a whole.
yes. But on the same time, that is so, there is no need to exclude the company in the amended control order. Amended control order. Why you are
The
excluded?
company also, there is nothing akin to company.
No, today there is
Because
no
group
group
of
of individuals. Then why you have excluded?
All right.
So specific term should be there who is not entitled to.
Very.
Had there been group of individuals, I could have understood. The moment group of individuals withdrawn, there is no need to mention in company that you are not part. You are part. Following the same principle, I should have been included in the restriction list or the non-eligibility criteria.
All right.
The division bench, possibly, Your Lordship, my submission has been understood that you have excluding.
You'll understand only when you deliver the judgment. You never. We think that the judge has understood, then we find that
Submission.
nothing understood.
Not that really.
Entirely solid. I mean, you need a hammer and a screw. You'll understand only when you deliver the judgment. We can pose that we have understood. But apparently we have understood. We think that we have understood, which is not a good test because we don't know whether we have understood. Yes, we'll put it this way so that you can ascertain that whether you have understood actually. Now, previously there was group of entities, company was not there. Logic of the division bench was because there is no specific bar, it has to be constituted under group of entities. Now, here, since company has been specifically barred, although group of entities, individuals is not there, individual is there. So, by incorporation of this bar, it presupposes that company could be misconstrued as any of those.
Absolutely.
So therefore,
whoever may be barred,
that logic applies.
yes.
Very
Whoever barred, that should be incorporated in the last line of the notification.
very
Just a minute, my lord.
Yes,
And so far the judgments relied my learned senior friend. I can show from this judgment, it says having the right to revoke.
Yes.
Having the right to need not go through the same.
Mr. Doctor's judgment.
Yes.
85.
Yes, 85. So I tried to show before Lordship that on the date of cancellation or revocation of my license, this power has not been vested to the subdivisional controller.
No.
That is subsequently. And even today, subdivisional controller has no right. Unless there is an intimation from the district level sub-selection committee.
Even today or today we don't know because today it does not have right. Whether we can use the word even because if the right was not specifically circumscribed, today the doctor may argue that
even not even
today they don't have a right to know. But whether they have a right, we have to decide. We have to think about that. And it's a very strong argument of yours that now it has been incorporated, not vested with the licensing authority. So whether, I mean,
assuming the power,
yes,
of a higher authority.
But that argument would be valid today. Today, licensing authority cannot do it. But when the law was silent on it,
not silent.
Then
no, not.
Revocation law was silent. Now it is very vocal.
My respectful submission, this was not a revocation, this is a cancellation. Because the revocation, there is no term in the control order. Before this amendment.
Yes.
If it is cancellation, learned single judge says proceed. Simply order you proceed. Cancel the license. Invoking the provision for cancellation of control order.
Really?
That's my submission, Lord.
Thank you. Yes, Mr. Doctor.
Now, my lord,
Short reply.
I'll just short reply, my lord.
subsequently introduced higher authority.
My lord, this I
Have to
just
start with that in.
I start with that only.
Yes.
Lordship kindly comes to the gazette notification, the amendment of the control order 2024. My lord, the first paragraph, the number so and so. As now, therefore, is the power conferred by Section 3 and Section 5 of the Essential Commodities Act. Governor is pleased hereby to make with immediate effect. So the effect is from the date of notification in the official gazette. That is
Prospect.
yes. No. Yes. So, my lord, this
After your relevant period.
yes. Now, my lord, the impugned order of cancel revocation, the impugned judgment, all were passed, and this was not on not considered. There was no scope for consideration.
But so far, my learned junior friend properly possibly assisted the annexure of my exception, the inquiry report. The last column number 78 says the inquiring person and applicant submitted all the requisite documents in favor of the application for getting universal lordship and verified all the submitted documents.
No, obviously,
Yes.
inquiry report means it.
Yes, it is.
That was-
I admit that everything was said to be verified, but upon further scrutiny is found to be otherwise. That's why this revocation.
Suppression.
I have never said suppression that way. I have said you have not
First
come
one
to court
goes
with
well.
clean hands.
First one goes well.
Yes.
Now, my lord, my lord, the law prevailing on the date of the
This is not the law.
It's not the law. So, my lord, this is not the law.
But
Therefore,
Mr.
this-
Sahara argues that by incorporation of this, it necessarily implies that you did not have any power to revoke.
No,
That
my
has
lord,
been introduced subsequently. If you had that, what was the necessity of it?
I just take your lordship to the writ petition, my lord, the impugned order. Page bolo tatadi. Lordship kindly comes to page 85. Page 85 once. This, I believe.
May I just cover?
Yes, yes, sir.
Page 85 is 24th March 2025.
Yes.
But this notification is of 12th September 2025. This did not see the light of the day
No.
when this order was passed.
No.
My lord, I just take your lordship has perused this time and again. But my lord, second paragraph I just read, just to cut short your lordship's time. Whereas Kandisini was accorded approval to get APS license on 17th of September 2024, after being recommended by the district level fair price shop selection committee. So this was only a recommendation, and recommendations never binding. So, my lord, this is a procedural aspect. An authority recommends and the other authority grants. So, my lord, this recommendation, many things have been said, the district level fair price shop committee is now under the, your lordship kindly ignore this because this was not there when the writ petition was disposed of or the impugned order in the writ petition was challenged. Now here, my lordship kindly says, this was merely recommendation. And then, my lord, this next paragraph, whereas on further scrutiny, this is a subsequent revelation on further scrutiny. It revealed that Kandisini is not a cooperative society. Your lordship knows, I don't want to repeat that. But he could not produce. Opportunity of personal hearing was given.
No, hearing was, well, Mr. Sahara placed it, that hearing.
Yes.
And we have seen the
And
handwritten
kindly
release
sees the
also.
page 84, lordship kindly sees what he said. During hearing, personal hearing was given. My lord, this page 84.
Yes.
Lordship kindly sees. It's in Bengali, so and so, আমি so and so. আমি so and so বর্তমান কান্দিসিনি সম্পাদক আমার আপনার প্রেরিত চিঠি so and so 11/3/25 তারিখে ছটার সময় হিয়ারিং উপস্থিত হয়েছিল
হয়নি
হয়েছি
আচ্ছা দিস
হয়েছি অতএব মহাশয় যাহাতে হিয়ারিংটি হয় তার সুব্যবস্থা করার জন্য অনুরোধ জানাচ্ছি so my lord, he is the secretary of the Kandis region and he participated in the hearing and this was his written declaration on 11th of March 2025. So this has been relied on at page 85. Last but two
declaration, nothing. He says that Just to record that he has.
It is the attendance of the secretary.
Yes, yes.
That's the attendance.
Whatever is there.
This is nothing.
But here, my lordship kindly sees now the last by 2 paragraphs, last sentence. But he could not produce cooperative registration certificate. This is what is important.
Even today, Mr. Shahara's case is that he does not have that.
Yes, does not have. So, well, admittedly,
at all.
and in the supplementary affidavit, I said so in so many terms, and nothing has been denied. And the last paragraph, lordship kindly says, therefore, in terms of clause 11,
You can, if there is any bottle or
No, sir.
water, you can have water. No difficulties.
excuse me, I'll just.
We have a bottle of water. If you can, no. Actually,
No, lordship.
এটা দিয়ে দিন না ওনাকে. You can have it. Not serious things.
It happens, my lord. I'm aging.
Please.
You shall not put this type of foot in here, my lord.
I'm so grateful, lord. আমার কয়েকটা এখানে কেউ নেই জলের বোতল এখানে পড়ে আছে এনে তো দিতে পারে
Yes, Mr. Dakar, please continue.
Lordship, the last paragraph I was placing page 85.
Yes.
Therefore, in terms of clause 11, Roman 4, part 5 of the notification, that is, my lord, page.
Notification is at
Page 87 onwards. It is, my lord.
Yes.
The lordship has to see 11, Roman 4. Yes. Page 90. 11, Roman 4 is page 90, my lord.
Yes.
Roman 4. Any suppression of fact, information, or incorporation providing of wrong information in the application form or attached documents will be considered as a good and justifiable reason for disqualification of a candidate or rejection of application and taking appropriate legal action. Now, my lord, lordship, pausing here for a moment. Your lordship is considering a case of the representation as a new applicant here. It's a new applicant.
That is where Mr. Shahara joins issue. I mean, he says, I am already a vested right has accrued in my favor. I am a licensee now. I am not at the stage where I am an applicant and you can reject my application or disqualify me.
Yes.
I have been qualified, granted. Now you cannot resort to that. We have to decide that. But that is the bone of, you say, no, it relates back to that date. Because the infirmity was of that date and ab initio, your ab initio argument.
That he was not an eligible applicant, therefore it was revoked. Now, my lord, here.
If you are not eligible at the inception, you cannot become eligible later.
Yes, later. This is the real bone of my contention.
Yes.
And this is, my lord, I showed to your lordship, my lord, the paragraph 6 of the vacancy notification.
Yes.
Page 88 at the top. Application is received from ineligible candidates will be summarily rejected. And this is in parameter with this Roman 4, paragraph 11. Any suppression of fact, information, or incorporation. But the information, but if your lordship takes information or incorporation providing of wrong information in the application form, well, the application starts with cooperative society. That is an admitted position.
But Mr. Doctor, what is your answer to Mr. Shahara's reliance on the coordinate bench judgment, where that division bench had held? There, the situation was the language was individual or group of individuals or entities. Division bench said company is not specifically barred, so therefore it can come within the broader perspective of entity or individual. That was the premise of that judgment. Now, Mr. Shahara says company has been put in the exceptions, but he is not a company, so he does not come. So why shouldn't the same logic apply? And when we asked him that there is nothing equivalent to group of individuals or entities, now Mr. Shahara has put in a very pertinent argument. He says that by introducing company under the bar clause, it is implicitly it is implied rather that company may broadly be misconstrued to come under any of these the eligibility criteria. So that's why a specific bar had to be made out. So it may broadly come within others also, like a registered society may come within this, suppose individual.
Well, with
That was the
respect
logic
to
of
my
the
learned
previous-
friend, but this is a very far-fetched argument. Very far-fetched.
But
Well,
Commission
the
bench proceeded on that.
analogy is very feeble in my humble submission. It's very feeble. It's a far-fetched. If I may say so, my lord, with deep respect, my lord, this analogy, my lord, Lordship kindly see the factual background of this case and that case. In what fact situation that judgment was delivered by the honorable coordinate bench, and here, my lord, the learned judge, my lord, completely misdirected himself to consider the status. Learned judge considered the status of the petitioner as a licensee, which is totally, my lord, a misconception. With due respect, I submit. It has to be considered as an applicant.
Has to relate back to the date of the
Yes.
issuance.
Yes.
That is your argument.
Yes, and the application. Well, in the application, it says cooperative society. And this, my lord, information, my lord, the influenced the authorities to scrutinize. But subsequently, they found, though these are all incorrect, there has been a mistake on their part and they have corrected it. As simple as that.
But in the meantime, vested rights had accrued in his favor.
No, my lord, this vested, this
is another
inherent defect does not confer any right, or that some ineligible candidate which should have been disclosed at the threshold has been disclosed, which my lord, dismissal ought to have been at the threshold has been done now, revocation.
Yes.
That through oversight or otherwise, well, there was an error on the part of the authority.
That will jeopardize and make insecure all licenses. I mean, tomorrow you will find you yourself, after having approved his license and granted him a license, he having functioning.
He has been functioning.
Creates an insecurity also.
The Lordship kindly sees, my lord, that here, my lord.
But you say that it was deliberate also in a sense that he knew he was not a cooperative society.
And in the affidavits, and they admittedly, they say, so therefore, my lord, that is the basis. And that's why I said is the application was void ab initio, and therefore the grant of license, that void license did not confer him any kind of right. That cannot be. Well, once it is bad for all time to come. So this is, and my lord, this the Lordship kindly sees this. My lord, this I know, my lord, that in the midway somebody is doing some business, and in the midway for somebody's laches he has to suffer. My lord, that's one kind of that he's harping on. I know.
Yes.
But my lord, Lordship kindly sees the law operates. Law operates, and here, my lord, this has been done in terms of the vacancy notification itself. That now that is clarified, but subsequent amendment in 2025, my lord, Mr. Sahale got it, my lord, before I got it, my lord. Now, my lord, this Lordship kindly sees
another FPS matter coming up.
Yes.
He doesn't want to take the risk.
My lord, when law operates, my lord,
yes.
Equity doesn't come in. It's by operation of law, as if there is no license given to him because of the inherent, my lord, the non-fulfillment of eligibility criteria, which, my lord, according to the vacancy notification itself, there is provision for summary dismissal.
We are just putting his arguments to you so that you can reply, and your arguments to him so that he can reply, so that you can get a complete picture of what are your answers to.
Yes, my lord, I think I have covered everything, my lord. I have nothing more to add, my lord. And my lord, this Lordship kindly says that he is trying to say some other cases. But your Lordship pointed out there cannot be, that's well settled, negative equality is not permissible. That is always there.
Parity ground.
Yes, I cannot perpetuate illegality.
Yes, but Mr. Shahara apparently meant that, I mean, that you are construing, you're yourself construing that clause to be registered societies to come within the purview of the vacancy notification. Because you have granted it to others, probably Mr. Shahara's premise of citing that was not negative equality only, but that your perception and your interpretation of that vacancy notification is that registered societies are also entitled. Probably he was on that.
Now, my lord, my lord, if the lordship kindly sees once again, then
It's arguable. It's definitely arguable.
That's the case, my lord. The lordship kindly comes to my lord page 87 once again, my lord. 87, my lord, it starts 87 or 88 bottom. My lord, the following person's entity, my lord, shall not be eligible to apply for a license of APS dealership, namely, a person holding a license of APS dealer or distributor or wholesaler in his name or person whose relative as per clause so and so already has a APS dealer or distributor or wholesaler license. A member of local bodies, local authority, Panchayat Raj, Board of Corporation, or member of Legislative Assembly or member of Parliament during his tenure in his capacity, a minor a person convicted by a court of such and such or in any criminal proceeding of such and such connected with essential commodities. My lord, this, my lord, to that, my lord, I would say, my lord, this is next page. Yes, next page, my lord.
So you constitute a corporation or company as a person.
Yes.
Following persons are not eligible.
But my lord, lordship kindly sees, my lord, this is say who will not be eligible. My lord, this clause or para 9 says who is eligible.
Yes.
My lord, para 6 comes before that. It says who is eligible.
Yes. You say you have to cross that threshold.
Yes, that is prior.
That threshold. This is a further.
Yes, that submission I also already
that
made.
we made.
I made. After 6 comes the 9. You just cross the hurdle of 6 and then you go to 9.
Right.
You were barred at 6th stage. Why are you relying upon this 9th stage? This cannot be done.
Right. Your closing argument.
Yes, yes, madam.
Hard-learned counsel for the parties. Hearing is concluded. The matter is reserved for judgment. আচ্ছা এই বইগুলো এর সঙ্গে পাঠিয়ে দেবেন। এইগুলোই পাঠিয়ে
PM fixed matter item number 6.
Yes. Yes, Mr. Dhar.
Yeah. The last occasion when I started, perhaps in my lord's brief, there was no paper book. এখনো পাননি? Oh.
ফাইল করতে বলছি
Paper books কি আনানো হয়নি ডিপার্টমেন্ট? রিপোর্ট দিয়েছে নেই? No paper books in department.
There
You
was
have filed. You have filed.
previously I had filed somehow misplaced. I'm giving a fresh.
Yes.
For our recapitulation, my lord, the initial writ petition was filed by Miss Ghosh's client before the Honorable Writ Court, alleging that state functionaries have rehabilitated few folks on their Raiti land, and hence kindly direct the state authorities, state respondents to evict them, removal from the Raiti land. That was the issue. And my lord, writ court has allowed the writ petition with caustic remark against the concerned BLLRO, that BLLRO has tried to mislead the court by filing affidavits. Initially, one affidavit in opposition was filed by the concerned BLLRO. Subsequently, the Honorable Court has directed to clarify her position by filing another affidavit, and by way of supplementary affidavit, another affidavit was filed, affirmed and filed. Upon considering both the affidavits filed by the concerned BLLRO, the Honorable Court has held no writ petition is allowed. Direction was given upon the state authorities that you remove those encroachers from the Rayati land, number one, and rehabilitate them in another land, and also upon the BLLRO, the 10,000 cost, 10,000 cost, and the caustic remark would be updated in the service book. So challenging that, this is the appeal. The other day, my lord, I had placed the relevant portion of the judgment, which is at page 74 of my paper book, starts from page 74. This relates to a one plot number, which is 1338, and the area of the land is 1 bigha, 11 kathas, 3 chataks, 10 square feet.
Yes.
Malad has got it. I'm not placing the entire judgment. Malad, I'm just keeping to that judgment. Malad, kindly come to page 79. That was the cause of action. Why writ petitioner came before this court. That agents of respondent Panchayat Samiti are taking measurement of the concerned portion of the said plot of land. On inquiry, he was informed that the lands were vested and were being measured for distribution thereto. This was the submission made by writ petitioner's advocate. Then, Malad, the Jila Parishad, as per the allegation made in the writ petition, the culprit is the Jila Parishad. Malad, kindly come to page 82 at the bottom portion.
Mr. Mukherjee submits that on 10th June 2003, this honorable court passed an interim order of status quo till 20th June 2003, being prima facie satisfied about the matter. There was direction for filing affidavit of service. It was also recorded in this said order that this interim order was passed in presence of concerned Jila Parishad, against whom grievance has been made. Mrs. Manjuli Chaudhuri, learned advocate, represented Jila Parishad. It is submitted that on 19 June 2003, direction for filing affidavit was given. Interim order was directed to continue until further order. Then, my lord, I am not placing those 2-3 lines. Then Mr. Mukherjee submits that even in spite of order passed by this court in presence of the Learned Council, Jila Parishad, and the state authorities, the concerned authorities acted contrary to status quo passed in this matter, and they have handed over the structures to those unauthorized roadside encroachers of NH2, and this was done in consultation with Public Works Department. Then, my lord, at the bottom, that Mr. Mukherjee, who also submits that the concerned BLLRO, who was directed to submit a report on earlier occasion by this court, submitted a report on 10th October 2012 before this court, stating therein that the land is not at all a vested land nor acquired land. According to him, plot number 1338 of Mouja Bali comprised an area of 47 decimals and was classified as Bagan during RS operations. The plot was originally recorded in Khotian number
But the
4673.
writ petition is not represented before us today.
Sorry?
Writ petition, you are
Yes,
for the
yes,
writ petition.
yes.
Your name was recorded for the private respondent,
Lordship,
the impugn order.
Lordship, after Lordship, in the writ petition, Your Lordship, the writ petitioners and the private respondent both are the owners of the land.
But you were not the writ petitioners, you were the private respondents.
What was the writ petitioners?
Your name is page 77.
I don't know.
Please see paper book page 77.
Lordship, herein for the petitioners, Your Lordship, they are also the landowners and also the private
Maybe on the
respondents
same
both.
footing, but you are not
Lordship,
the
Lordship.
writ petitioners, you are the private respondents.
That
You have forgotten that also.
now, since I'm representing
You are
both, Your Lordship,
representing the Pradeep Jaiswal and others also.
now.
At that time, they were private respondents.
Yes, but anyway. So you are representing private respondents in the writ petition as well as the writ petitioners. Yes, please continue.
Then Mouja Bali comprised an area of 47 decimals and was classified as Bagan during RS operations. The plot was originally recorded in Khotian number with intermediary status. Thereafter, it was incorporated in RS Khotian number such and such to such and such with the names of Haradon Huddut and others. The status of Khotian being Rayati, Dokholi, Shatto, Bishishto. Finally, the plot came to be recorded in the name of Srimati Shanti Devi Jaiswal, Vide mutation case number such and such. So, on the date of vesting, after RS operation had taken place, Huddut's name, who was the vendors of the present petitioners, name was there, and it was shown in the record of rights, Rayat Dokholi Shatto Bishishto. So that means I take it retained, and Dokholi Shatto Bishishto means on the date of vesting, they were possessing, they were in the possession of the land. The BLLRO contended that on physical inquiry of the suit plot, it appears that a metalled road runs through the northwest portion of suit plot, shows in the sketch map, but there is no reflection of any acquisition. Around 50 families who were evicted from erstwhile Vidyasagar colony, Makaltola, Durgapur, for widening of NH2 had been settled over the plot under the impression that it was vested, although no documents could be produced by the occupiers. The families have been living over the plot since their eviction in the year 2003. Many of the families received electricity connection. Local Gram Panchayat have constructed well. I'm not placing all those. Then kindly turn to the next page. I'm sorry, just last two sentences of the previous page. Each family occupies 500 square feet of land. In fact, the secretary of the colony committee had applied to the district refugee relief and rehabilitation officer, Howrah, for regularization of the colony and allotment of pattas over the said plot. However, it was mentioned that the colony also occupies a plot of land being plot number 1446, which is vested.
Dispute is regarding that 1300 something. That
Yes,
plot, not
1338 only. Then kindly come to the last portion that Mr. Mukherjee points out. In the affidavit in opposition, one Ruma Sarkar, claiming to be the present BLLRO Bali Jagacha, affirmed an affidavit annexing some documents to show that the Calcutta Special Road Division, video there later dated 29th March 1964, requested the collector Howrah for handing over the possession of plot number 1338 along with other plots for execution of NH2 project video proposal under LA case number 3 Act 2 of 1963-64. Again, my lord, kindly mark this. Whereby the then collector Howrah, video his order dated 28th October 1964, informed the executive engineer PWD, stating that several plots, including plot number 1338, were notified for acquisition of railway colony, and as per report of Kanungo dated 20th April 1964, the said plot was under the possession of Eastern Railway Authority. Then Mr. Mukherjee submits that not a single scrap of paper was produced or annexed by the present BLLRO to show that the land was earlier acquired by railway authorities or by the state authorities. He submits some copies of the letter and the corresponding were produced, which are not at all relevant and or material to show that the plot in question was acquired or vested in the state. So next paragraph, Mr. Mukherjee points out that the BLLRO deliberately and intentionally affirmed a false affidavit on 13th August 2013, stating that plot number 1338 is acquired property, and suppressing this fact, petitioner misrepresented and took money from the bank. Because by putting that particular land, the subject land, they perhaps took a loan from the nationalized bank. That's why. Her affidavit is contrary to the report of the earlier BLLRO, who has submitted his report on 10th of October 2012. Mr. Mukherjee then points out that this false statement was made without any supporting documents or without any evidence. However, she was given an opportunity to correct herself by affirming a fresh affidavit. Then, my lord, again, Mr. Mukherjee has submitted, instead of correcting her, the BLLRO filed a supplementary affidavit affirmed on 25th February 2014, again with false averments to the effect that the right title and interest of the intermediaries were vested to the state in respect of the said land as per provisions of sections 4 and 5 of the West Bengal Estate Acquisition Act 1953. This honorable court once again asks the BLLRO to produce the records in support of her contention and claim that the land has been vested under sections 4 and 5 of the West Bengal Estate Acquisition Act 1953. Then Mr. Mukherjee submits that
First it was submitted that it was under the LA Act.
Yes.
The stand was changed to Estate Acquisition Act.
Never changed. I'll take to my lords to the affidavits. What has been stated by the BLLR? Perhaps wrong appreciation. Anyhow, Mr. Mukherjee submits that Mr. Pal, Learned Counsel, appearing for the BLLRO, submitted that whatever records the BLLRO had she disclosed those records in her supplementary affidavit. Mr. Mukherjee submits that from the record of right, which was annexed to the supplementary affidavit, clearly shows that the aforesaid plot of land is a Raiti land And as per Rule 4, under the West Bengal Estate Acquisition Act 53, any land retained by any intermediary under provision of subsection 1 of section 6 shall, subject to the provision of the Act, be held by him from the date of vesting on the terms and conditions stipulated in the rules. Mr. Mukherjee submits that as per Rule 4, the writ petitioners who are the predecessors were intermediaries. They have got their Rayati Shotto declared, which was recorded in the record of rights. Then, Malan, I'm skipping over. Those portions are right under Article 300A that cannot be curtailed without paying any compensation, and those lines of
think this order on the merits also, or only the BLLR?
Only the BLLR part.
So on merits you are not challenging?
No. Now, let kindly straight away come to page 99. This was the analysis given by the learned judge, and I'll place just 2 pages from 99. This statement, 1, 2, 3, 4, 5, 6,
Yes.
7th line. This statement was made under paragraph 3 of the supplementary affidavit dated 25th February 2014 by Ruma Sarkar. She affirmed this statement true to her knowledge. After perusing the supplementary affidavit, Mr. Pal was directed to produce the relevant documents showing any such proceeding under West Bengal Estate Acquisition Act 1953. It is no doubt true by operation of law, all properties of big riots were vested in the state, subject to exercise of option using B form for retention of lands as permissible under the Act. In such case, big riot proceeding is initiated and the concerned revenue officer BLLRO decide the case allowing retention of lands as desired by the big riots as per West Bengal Estate Acquisition Act, and records are corrected showing Rayati Shotto on the retained land. So no such records were produced by Mr. Pal, learned advocate, who is representing the state authorities, including the BLLRO. Mr. Pal wanted to show some ROR wherefrom it appears that the lands are Rayati lands, and copies of ROR clearly indicates that the writ petitioners are the owners of the land and they were in possession at the time of hearing. Mr. Pal wanted to interpret some provisions of West Bengal Estate Acquisition Act, but facts remains that no single scrap of paper was produced in respect of claim and contention of the BLLRO, as made in 2 affidavits, once claiming the land is acquired.
Yes, please continue.
Yes. Acquired and subsequently claiming that the land is vested in the state under West Bengal Estate Acquisition Act. It is thus evident that the concerned BLLRO deliberately and intentionally made a false statement before this court to misdirect the honorable court and in fact to justify an unreasonable and unlawful stand taken by the state authorities. Now the question arises whether the respondent authorities, including the Jilla Parishad, Panchayat Samiti and district administration, can dispossess a lawful owner from her property by adopting. This part I am not placing. Then Malad, I am skipping over. Malad, kindly come straight away to the page 102. Last line, Malad. Accordingly, this writ petition is allowed with a direction upon the respondent to remove the encroachers from the land of the petitioners and deliver back the peaceful possession of to the writ petitioners within 6 months from the date of communication of this order, and to find out a suitable places and or plot of land belonging to the state government or any of its organs to rehabilitate the occupants of the writ petitioner's property. The cost of such rehabilitation is to be borne out by the state authorities, including the Jilla Parishad and Panchayat Samiti. All the concerned respondents are restrained from issuing any sort of documents and or creating any right in favor of any of the occupants who are all unauthorizedly and illegally rehabilitated upon private land of the petitioner, for which the state authorities and its instrumentality are instrumental. This court has come to a definite conclusion that the BLLRO has made a wrong statement deliberately and intentionally affirming affidavits before this court as true to her knowledge, and these affirmance are not supported by any relevant documents. For these reasons, the concerned BLLRO is punished by awarding cost of rupees 10,000, and the DLLRO is directed to deduct the said amount from the salary of the BLLRO in the month of May 2014 and to pay the amount to the writ petitioners. Service book of the said BLLRO would record such punishment.
This morning we have stopped short of service book.
Yes.
Directed 50,000 cost to be paid by a BLR for continuously flouting orders of court. You should be put on caveat.
Well, let me.
But that was for flouting court's order to specific directions, flouted, sought to be reopened and all. Here it is something as misstatement.
Yes, yes.
Misstatement. Deliberate misstatement.
Yes. Now, my lord, kindly come to the affidavit part. Both the affidavits I'll show. My lord.
Yes.
My lord, that is one affidavit affirmed on 13th August 2013 at page 29.
Yes.
I'll not place, kindly come to straight away to page 30. What the BLLRO has stated in that affidavit. The relevant paragraph would be only 234, that the additional district magistrate LA Howrah for information regarding acquisition of land in RS plot number 1338 of Moja Bali, jail number 14, PS Bali, District Howrah, wrote to the project director, National Highway Authority of India, 119 Park Street, such and such, on 5th December 2012, with a copy to the district magistrate Howrah for information as to whether the land in question belongs to NH2 under National Highway Authority of India, and requested him to submit report by 11th December 2012. The copy of this, my lord, kindly come to page 35. My lord, I'll show along with the pleadings the annexure. This is the ADM is writing on 5th of December 2012 to the project director, National Highway Authority, seeking, it is very urgent. I'm placing from the second paragraph. On top paragraph, it has been mentioned about the pendency of the writ petition and everything. Then the land details, and then he is requested to submit a report to the undersigned by 11th December 2012, positively, in absence of which it will be presumed that the land had not been acquired in favor of the National Highway. Then, my lord, kindly turn to the next page, page 36. One is to the first one is to the project director, National Highway. Second one is to the executive engineer, National Highway. Same letter to the different authorities. Then, my lord, kindly turn to the next page, 37, to the superintendent engineer, Ministry of Road Transport, NH. Same authority is writing. Why the same authority is writing? That answer is at page 38. Not kindly turn to page 38. This is the document of 1964, 29th of September 1964. The then executive engineer, Calcutta Special Road Division, is writing to the then collector of Howrah that possession of plot numbers 1443, 1338, that is the subject plot, 136013 such and such, I am not placing, Moja Bali as per above proposal may kindly be delivered to this division immediately. For want of possession of these lands, the work is hampering to a great extent, and early action in the matter will be appreciated. Kindly excuse me, my lord, on the right hand side, before the date has been mentioned, 29 September 1964, the Kanungo has made this remark on that.
You can't read.
Very, very difficult, but this, it's showing that colony case number, Vidyasagar, that colony case number as such and such, decision is made as to, so the possession is, they are handing, one is giving up the possession, another one is taking over the possession. Now, I'll kindly turn to the next page. Page 39. Again, this is from collector, the then collector Howrah, and between ex-engineer Calcutta Special Division, Road Division. This is also a document of 1964. In reference to above, this is to inform him that possession of the plot shown in the enclosed list could not be taken. On the plots were notified for acquisition for railway colony.
Mr. Dhar, on the previous page, it was not handing over possession. Apparently, the handwritten signature, although we can't read the handwriting, it appears to be decision is made as to handing over the possession.
Yes.
It says decision is made, not
actual handing over. I'm sorry.
This person asks for possession and he says the decision is taken to hand over possession. This much.
Yes.
And an LA case has been mentioned there. Number has been given.
On the next page, my lord, will find the same LA case number.
Yes. But this does not show that LA case has reached its culmination or vested or award.
Yes. The acquisition of the plots will not be possible for such and such condition of the such and such. That's how. Now, my lord, kindly turn to the next page.
Let us read this. Yes, please repeat that.
Yes. In favor of the
acquisition
proposed
of the
project.
Plots, acquisition of the plots will not be possible for acquisition.
Yes. For the proposed project.
Acquisition for the proposed project, project are linked. What he says is that the acquisition of the plots will not be possible for that project.
Yes.
So he says acquisition will not be possible.
The collector is saying.
Yes.
Yes. Now, my lord, kindly turn to the next page.
Yes.
This is the Form 13. This is the Form 13 and Form 13A. These are the forms published under Section 11 of the Land Acquisition Act. If my lord has the Land Acquisition Act 1894, my lord, on the back of it, my lord will find the Form 13 or Form 13A. দেখ না land acquisition বইটা is there any form mentioned in it? No. Well, I'll try to find out.
1894.
1894.
We don't find any form in this book.
Form 13 is in respect of total land. What would be the total land?
Under which section?
Under Section 11. Kindly come to that form in the paper book that is mentioned. Form 13, land acquisition, case number such and such, 1963-64. Then proceedings under section. It has got it. Of
1948.
1948.
West Bengal Act.
Yes. Both the forms, there is no different form for Act 2. Whatever award been published, it published only on Form 13. It may be under Act 1, it may be under Act 2, it may be under Act 3. And Form 13A is if there are several plot holders, their share and area would be mentioned and their proportionate awarded amount would be mentioned. So Form 13 deals with the entire area and entire compensation. That is Form 13. And Form 13A is individuals' share and their pro rata basis awarded share. Then Form 13.
Form 13 is submitted by whom?
This is the it was annexed in that report.
It's submitted by whom under the law?
Under the law by the collector. That form has to be signed by all the land acquisition officer, then special land acquisition officer, then collector. 3 to 4 authorities, they sign underneath of that award usually. And language of section 11 says that award has to be declared by the collector. So it has to be signed by the collector. So these are the documents were available when the concerned BLLRO was asked to file a report. So BLLRO could not have ignored all those documents which she has annexed along with the affidavits. Now, my lord, I'll show from the statements that BLLRO has not misled the court. BLLRO has stated in the pleadings that due to conjoint effect of 4-5, every land got vested. That is the notional vesting. And subsequently, under section 6, it was allowed to be retained. That's why Rayat Dakoli Satto Bishishto. And those porchas were also annexed along with the.
And these lands were outside the 1330, it was outside the purview of the vesting. It was permitted to be retained.
May I? The concept of West Bengal Estate Acquisition Act, every land of state of West Bengal gets first vested to
by
the
default, unless they're retained, they're permitted to be retained.
Yes, first vesting happens.
And those retained, then you cannot say that's a vested land.
6-1 proceedings, if I may permit to say this, 6-1 proceedings is not the vesting proceedings. 6-1 proceedings is the retention proceedings. We all say, oh, that show me the vesting proceedings. That is actually not vesting proceedings. That is actually retention proceedings. So BLLRO has
say in your statement, writ petitioner cleverly knowing that the suit plot is acquired property and suppressing the
yes,
facts.
because of this acquisition documents. Award, even award Form 13 was there.
Form 13 does not contain 1330, does it?
Form 13 is only
all the plot numbers are given here.
Yes, total
plot numbers are given.
Yes,
total has to refer to certain plots.
Yes,
1338 is not there.
Yes,
page 48, 1338 is not there.
Yes.
So what are you saying? And
it was not
coupled with page 39, which says acquisition is not possible for 1338. So these two palpably show there it was not possible and it was not done.
There were conflicting documents.
What
That's
conflict?
why
Where is the conflict? 1338
the
is
Kanungo's report to show that give the possession.
Where is report is not a report. He said that give the possession.
Yes.
How does that mean that
that is
affirming on oath, Mr. Dhar, that it has been acquired? Not only that, she says that deed in question is void, illegal, individual, and never acted upon. Writ petitioner cleverly knowing the facts that suit plot number 1338 is acquired property and suppressing. She says it's an acquired property.
Yes. What has prompted her to say this? Because of this page 38, 39, and 40. She was confused.
She says in Roman 12 that writ petitioner admitted that it's a retained land.
That is why the then ADM in 2012 was asking for the documents from the railway authority.
She does not stop here. She says, I deny that writ petitioner on such and such came to know that suit plot was occupied by. And then she said, I state that the alleged mutation by the then BLLRO by order date such and such was illegal, invalid. Why illegal, invalid? Because it was acquired on the basis of that. She says categorically in para 4 that it's acquired property.
Absolutely. My lord, I'll take my lord to the para.
That is entirely misleading.
My lord, during that time, only those reports were available. My lord, this was when
These reports do not show that it is acquired.
Yes. My lord, it is not concluded acquisition. That time she
is not concluded.
My lord,
She does not say acquisition proceeding. She says acquired.
That
Acquired means
that's sort of a difference, my lord. The land
between
reforms
being acquisition proceeding pending and acquired.
64. Kindly consider
64?
that aspect.
What 64?
Now, this acquisition of 1963-64.
She could have said, I don't know who prevented her. I do not have the records. She could have said, I do not have the records. These are the records.
Not
how does she affirm an affidavit saying that?
I can.
And she doesn't stop here, cleverly knowing the facts that suit plot is acquired property. How can she say it's an acquired property?
These affidavits been drafted
Both
by
the learned advocate as well as the
that is the
should have been
problem.
penalized.
That is the problem.
So we'll penalize you for we'll shift the cost from the BLRO to you. We'll say you are defending her. That means you are complicit in that.
All
you pay her.
All the pleadings.
You pay her cost. We'll direct you to pay her, compensate your client by paying the cost to her. Because the advocate then was responsible. So you are carrying the legacy and you are supporting her. That is sufficient compliance. You are being complicit to this misleading the court. You pay her the fees. We are mitigating that grievance of yours. Now we'll ask you to put in the costs. Do that, Mr.
Well, she was not at fault at all. He provided all those documents.
She's an innocent baby. She has come and signed, and she states on oath that it is an acquired property. And what wrong did the court do?
She would have lost her job even for not providing the actual state
Some
of
cases
affairs.
Some cases should. One or two losing their jobs would teach a lesson to the others. You should be very careful while affirming affidavits before a court of law.
Both the swords are.
We will modify the order. We will modify the order and also impose cost on the advocate representing that this BLR. We'll do that.
BLR was not at fault. BLR, whatever document BLR.
Record your submission, Mr. Dhar. We'll say that BLR was not at fault because it was an advocate's drafting, and on the basis of your submission, we'll impose that cost on the learned advocate, and not say that it will go to his service book because the advocate does not have a service book. We'll record your submission. On the basis of your submission, we'll refer it to the Bar Council. Let us do it. Want to protect the BLR or BLR, you protect. But then you say the ground of your submission is that BLR was she was naive and it was her advocate who drafted. So let us impose on the basis of that submission, we will impose in the cost on the advocate, and instead of service book, now it will go to the Bar Council.
Now, kindly
let it be referred.
Kindly come to the next affidavits.
On the basis of your submission, Mr. Dhar. You want to protect the BLR or protect her. But then your ground of protecting her is that this was advocate's drafting. We'll record that.
These are the documents where
we'll record that. We accept it. We accept it. The BLRO might not have been acquainted with law or English enough to draft this. So it was the advocate. We accept your submission. And on the basis of your submission, we'll do that.
Kindly, before my lords,
what is the other affidavit? She was given an opportunity.
46.
Let us see that.
The Honorable Single Bench has felt that this.
We feel that the learned single bench should not have protected the advocate. It should have been equal. The hands of justice, the hammer of justice should be equal on the advocate and the litigant. Because if I don't hold, Mr. Dhar, that's a different proposition, that you are not responsible. But if I hold, then this drafting cannot be done by a BLR. We don't know. We should not make a comment on that.
Now, kindly come to page 47.
We have not even seen the advocate. Let us see now. Because you are casting blame on that advocate. So we have to see whom you are casting.
I'm not blaming.
Absolutely. The premise of your argument is that. These are our drafting.
Kindly come to page 47.
We'll not spell out, but we'll just. No. Where is that order again?
The impugned order. Page 77. Onwards. Starts from page 74.
He's still there. Mr. Dhar is still there. We don't know. I don't know him.
I don't know. I don't know.
Yes, page 47 is the next one.
Well, page 47 is the
This is
next. It
47.
starts from page 46.
Posthumously cost award করব আর ওর কথার ভিত্তিতে
আমরা কোটা প্র্যাকটিস করতাম।
অ্যাকসেপ্ট করব, সাবমিশনটা অ্যাকসেপ্ট করে বলবো যে ঠিক আছে বিএলআরও দায়ী না। Yes,
Manor Kanye.
and you will be responsible for that because it's your submission we are accepting. Fully agree.
I'm being intimidated.
No, we are accepting your submission. You are being encouraged to make such submissions.
Kindly
That the
come to,
poor litigant is saved.
kindly come to page para 3. Didi, ek second, at a place koreni. I further submit as it appears from the records that the Haradan Huddut, such and such, both sons
Show us the worst portion, Mr. Dhar. Show us the worst portion. Oh, this is the worst.
This is the
worst.
these 2-3 paragraphs only.
Yes, right.
Para 3 and para 4. I'll rely only this para 3 and para 4.
Yes.
She has mentioned that under West Bengal Estate Acquisition Act and as per the rule 4A, these particular plots have been retained by the intermediaries.
She says that I further submit as it appears from the records, all the hududs are mentioned.
Yes.
All sons of such and such were recorded intermediaries in Khotian number such and such this
Yes.
plot.
Yes.
The right and title and interests of the intermediaries were vested to the state in respect of the said lands.
Yes.
As per provisions of section 4 and 5 of the West Bengal
Yes.
Estate Act.
This is the notional vesting. Then, kindly come to the next sentence. I further submit that the Khondo Khotians being numbers such and such were opened in respect of the said plots in the name of the said Hudduts as per provisions of the West Bengal Estate Acquisition Act 1953 and rules framed thereunder. So that is the rule 4A. So retention can be...
You are very categoric on this acquisition, but you are not very clear on whether they were retained. They were opened in respect of the land, which does not mean anything.
Now, kindly come to the annexure.
We are not interested. Yes.
Annexure, page 50. I have provided all the RORs and on the right hand side, Moddho Sattokari Chirosthai, Malad has got it at page 50. Then Malad kindly turn to page 52. Charnong Bidhimote Rayat Dokoli Satto Bishishto. Malad has got it, page 52. On the right hand side. Second, after attestation, Charnong Bidhimote Rayat Dokoli Satto Bishishto.
No.
On the right hand side, second column, at page 52. Charnong Bidhimote Rayat Dokoli Satto Bishishto. Then, kindly come to the next page, page 54. That is again Charnong Bidhimote Rayat Dokoli Satto Bishishto. So everywhere, my lord, will find
These were annexed to the affidavit.
These were annexed to the affidavit. And all of these affidavits, all the annexures are showing the fact that this land has been retained under Rule 4A of the West Bengal Estate Acquisition.
Cannot say these are vested. Then all lands in West Bengal are vested.
Vesting is
ridiculous, Mr. Dhar. This is a peculiar argument. By default, all lands vest, some are retained. Obviously, the lands which are retained are not vested. The vesting procedure
happens fast.
No, that vesting is tentative, Mr. Dhar.
Yes.
That is subject to section 6. You cannot say that the land was acquired and vested. You cannot say unless section 6.
Acquisition is under different.
Yes, affidavit she says acquired.
Yes, for that,
here she says.
I'll take your lordship to the next paragraph.
You cannot say vested. We are sorry, very sorry. We are unable to accept that submission of yours, Mr. Dhar, that you can say by default everything vest, so I say vest. No, vesting is complete only after exercise of sections under section 6 is done, if it's this act.
That's
that
why
exercise is done. How can you say it has vested?
That's why she stated, I further submit that the Khondo Khotians being numbers have been opened. That's why Khondo Khotians. Now, kindly turn to the next paragraph. I submit that the avertment made in paragraph 4 of the affidavit in opposition affirmed by me on 13th August 2013 is based on letter issued by the executive engineer, Calcutta Special Roads Division to Collector, Howrah, in reference to land acquisition as per LA case number 3 of such and such regarding delivery of possession of the several plots, including plot number 1338. In the first letter, 1338 was there. That on such and such executive engineer, Calcutta Special Road Division, Government of West Bengal, sent a notice to the collector, Howrah, regarding land acquisition as per LA case number such and such, claiming the possession of plot number.
Another misstatement. They did not claim possession. Claiming possession means I am in possession. If I claim possession, Mr. Dhar, that means I am in possession. He did not claim possession. That person wrote, as per above proposal, may kindly be delivered.
It
to the
should have been
immediately.
asking for possession or requesting for possession.
Claiming possession.
Not claiming.
Claiming possession is entirely different. This is precisely what is misleading. Once you say it's acquired, then you say it's vested. Vested. Then Khondo Khotians were opened, which is unclear. Then the previous affidavit she explains by saying that a particular letter, in that the PWD engineer claimed possession of plot number such and such, which is entirely false because
Not
he did
claiming,
not claim possession.
It should have been sticking.
As per proposal may kindly be delivered to this division immediately, which was said decision has been taken to hand over possession. So where is the process of acquisition? How, even on the basis of that, how can you say it is acquired? Unless you see the award. And you have
only one.
She was equipped with the award, Mr. Dhar.
The complete document. That's why.
Then why write that it's acquired? And not only that, she does not stop there. She said, she makes a specific allegation, Mr. Dhar.
Kindly read the rest of the evidence.
No, she makes a specific allegation that the writ petitioners cleverly knowing the facts that the suit plot number 1338 is acquired property and suppressing the fact and misrepresentation took money from the bank. What is this?
Now,
a report was sought by the court from the BLL. Court relied on the BLL.
Yes,
and this is what you do.
Has pointed out. Then the second affidavit, BLLRO, is clarifying.
Clarifying that I acted on the basis of a letter which he claimed possession. Did not claim possession. He asked for delivery of possession. Anyway, let us
now kindly come to the Roman 3. That on 10th of October 1964, the Kanungo made preliminary inspection report against aforesaid letter dated such and such, stating that those plots were notified for the acquisition of the railway colony case.
Yes.
The Roman 3, my lord. Again, my lord, that on 10th of October 1964, the Kanungo made preliminary inspection report.
KGO is Kanungo. Why do I write KGO? Sounds like KGB sort of thing. KGO, why Kanungo is KGO? Is it KGO or Kanungo?
That's how they sign, my lord. That's why.
All Kanungos sign KGO?
KGO.
All Kanungos?
That I know.
How many Kanungos do you know? KGO is Kanungo. Are you sure about that?
Yes. Made preliminary inspection report against
Da KGO. Why do you write Da KGO? It's a post.
Yes.
Kanungo is a post. Achha. Oh.
Aforesaid letter dated 29th September 1964, stating that those plots were notified for the acquisition of the railway colony case at the right hand upper corner of the annexure 14 of the affidavit. In opposition, affirmed on 13th August 2013. And that on 28th October 1964, the collector Howrah issued a notice to the executive engineer, Calcutta Special Road Division, that regarding acquisition of additional land of NH2 in case number such and such. However, it is submitted that notification under section 41A of Act 2 of 1948 and award of compensation for plot number 1338 are not readily traceable in the office of the Special Land Acquisition Officer, Howrah. Then I further submit that the Special Land Acquisition Officer, Howrah, wrote a letter to the Senior Division Engineer to Eastern Railway stating inter alia that it appeared from their record that the plot number 1338 under JL number Bali taken over by the Eastern Railway Authority before 1963-1964, and he was requested to confirm the status of the land in question, as the petitioner has claimed the land Rayati property before the High Court, Calcutta, such and such, dated 31st December 2012. The said senior divisional engineer manager was once again requested to send report regarding CS plot number 1338, jail number Mouja Bali, which was alleged to be taken over by the Eastern Railway Authority before 1963-64. Vide memo number such and such. By no such report was received. Further, the district magistrate and collector Howrah, vide memo number such and such, 6 November 2013, wrote a letter to the senior divisional engineer, Eastern Railway, DRM, Howrah, for information whether plot number 1338 Mouja Bali has been acquired and taken over by the Eastern Railways before 63-64. So these are all these, Malad, even before Malad, after I filed the appeal, the Honorable Coordinate Division Bench has directed me to serve a copy upon the railway. Railway did appear, and throughout the process, Malad, railway could not produce any papers, and that was noted by the Honorable Division Bench. So actually, Malad, it was not a fault of the concerned BLLR. Whatever documents she could lay her hands,
those documents show that it was not acquired. That is our problem.
Record keeping is very bad in the district. That's why
the documents which she annexed to her affidavit do not corroborate the statements made in the affidavit.
Not the first one. First one says, yes, give the possession. That plot number is there.
For that, she writes, writ petitioner cleverly knowing the fact that suit plot number such and such is acquired property, and suppressing the fact and misrepresentation, writ petitioners took from the bank. On the basis of those documents are before us. Those were with her, she annexed. Those documents, one document saying that please deliver possession to me. On that stated that decision has been taken to deliver possession.
In the supplementary, she clarified everything.
Clarified everything by saying that it has vested and they claimed possession. Claimed possession is there, claiming possession.
Claiming possession, that particular
vested,
word.
Subsequently, one like Iti Gojo.
No, not Iti Gojo. Opening was open. And annexed all the.
Let us hear them. This is your entire case. Yes. Any judgment you want to cite? Mr. Dhar?
Yes.
Any judgment you want to cite? What should be the limits of the powers of court in contempt and all this? Yes, let us say, Miss
the scheme of the West Bengal Estate Acquisition Act.
Will you do with the scheme? It was your statements in affidavit on the basis of your documents.
That vesting, that notional vesting. The Honorable Supreme Court, in Suburban Agricultural Dairy Fisheries
which para?
Limited, page para 6 onwards, has categorically explained that conjoint reading of 4-5, it gets vested. Then simultaneously under section 6, kindly read from 4, paras 4 onwards. And the effect of 4.1.2 and section 5 and 5.1.
What was the argument?
Yes. Kindly read from para 6, 7. And vis-a-vis para 8 regarding the riots. This was for intermediary, chapter 2. Chapter 6 is for the riots.
Did she deposit that 10,000 cost? Pay that 10,000 cost?
We obtained the stay. $1996. কোনটা দেব সেটা দে, প্যারাটা বল।
But your first affidavit was completely false statement.
Regarding the acquisition part.
That is the part on which cost was imposed and this penal.
I have explained, my lord, in the later affidavits. As soon as I got the chance,
Yes. Let us hear the other.
now, my lord, I'll be relying on
How many more judgments? Mr. Dhar?
only on the issue of caustic remark.
How many?
One or two. My lord, two. Well, 1996. They are.
Give the citation for them.
1996, volume 6, SCC, page 234. And the previous one, 1993, supplementary 4, SCC, page 674. That was on the scheme of West Bengal Estate Acquisition Act. And this one is, my lord, on caustic remark. What would be the প্যারাগুলো বল আমার লেখাটা বল না প্যারা 7, 8, 9 and 10. ওই জাজমেন্টটা দে না যেখানে
7, 8, 9, 10. Or para 6.
প্যারা 6.
Or two judgments together. First judgment is 1996, 6 SCC 234.
Yes.
That probably para 6 or
7, 8. Oh, para 6. Manad is
para
right.
6. There's a
Para
test.
6, 7. Yes.
6 is the test.
Yes.
So here had opportunity of explaining evidence on record bearing on that conduct justifying the remarks. Evidence are your own annexures.
Yes.
Which show that they are not justified.
This second affidavit, my lord, I have explained, my lord.
Whether it is necessary for the decision of the case, yes, definitely it is. Let us see what else.
Then, my lord, the other judgment, like para 24, 2007, volume 3 SCC, page 587. এটা তো দিলীপ কুমার ডেকাটাই এটা দিস না 2023 টা দে
2000 আপনারটা অন্য সই annex না দ্বিতীয়টা আছে
in that compilation perhaps I have given
আগে
দিলীপ ডেকাটা রিলায়েট তারপরটা 1963
দেখুন ওটা
পেজ
এটা প্যারা 24
এটা মানে আফটার 2007 3 একসাথে সেলাই করে কি বলবো হ্যাঁ ওটা বলে দিয়েছি তো
here Deca has been reiterated.
Absolutely reiterated manner.
What was held here ultimately? Let us see that also.
This is one on
Expunged, yes.
Expunged.
Observations, strictures were made against the chief minister.
Yes. Here I am.
Courts were bolder, much bolder than us then. What was said? Let us see that. Now we are interested.
Audio alterum partem. And the last one would be 2023, volume 20 SCC.
Why have you annexed 63?
63 I'll be again on the same. That's why I'm not placing page paragraph 10, 11, 12, 13. And 2023
What was held in
2023 volume 20 SCC page 113.
What was 10, 11, 12? What did I see?
Para 15 to
21.
তাই তো?
It was held that High Court can expunge adverse remarks.
Yes. Once I got the opportunity, whether I have clarified my situation before the court.
Held 2023, it was held. Power to expunge remarks must be exercised with care and circumspection. Since it is an undefined power, said power to be exercised only to remedy flagrant abuse of power. Do you feel there was a flagrant abuse of power in the impeachment order? This goes against you. Their registration and investigation of a criminal case was directed against the person.
Here,
these are nothing. 10,000.
2-3 documents showing that 1338 was involved. As soon as I got the opportunity, when court has asked me, by that time, that exercise by the then additional district magistrate has been done with the senior divisional manager of the railway, and all those facts I have put it in my next affidavit that these are the communications made and these are the documents. I could lay my hands and clarified the situation that 4-1A I did not get it. Even the award copy I did not get it in my record, though I was the acquiring authority. The record should have been kept in the custody of the acquiring authority as also in the custody of the requiring body. The BLLRO is the custodian of the block, not the district.
Did she write that in an affidavit that I am not in custody of the papers and I don't know? What is the harm in saying that from the records I cannot enlighten the court? She could have said that. If I make a false statement, it was acquired, malafide. Anyway, let us hear the other. Ms. Sinha, you don't have much of a stake in this, probably. Do you have anything to say on this? It's a writ petitioners who.
I am foreign under the Howrah Jilla
Zilla Parishad. So you are not nothing against you. Let us hear Ms. Ghosh. Yes.
Lordship, at the time of filing of the writ petition, the petitioner had relied on the mutation certificate, which was duly signed by the then BLLR. Now, Your Lordship, I'll only place 2 documents. Since everything is placed, Your Lordship, this is a 2003 writ petition, wherein the petitioner had come to know that on their land, poles were being fixed and rehabilitation had started.
That was your cause of action.
That was my cause of action. And in the year 2014, it was directed that the state authorities, including the Howrah Jilla Parishad, DM, ADM, BLLRO, should take effective steps for rehabilitation of those encroaching, and peaceful possession should be handed over to me within 6 months.
Yes. The scope of this appeal is now limited to this remarks.
Now they are.
You argue, make your arguments. The rest they are not challenging. We are not touching even.
Lordship, with regard to the cost, Your Lordship, since Your Lordship, this is an appeal made by the state authorities, Your Lordship, I'll not enter there, Your Lordship. The only statement which I'll place, which is page 46, their own affidavit.
Yes.
I'll state only this much, that the BLLRO is stating that I have gone through the records of the case and well acquainted with the facts and circumstances. I have been authorized.
Which paragraph you are?
The first paragraph.
Yes, first.
I have gone through the records of the case and well acquainted with the facts and circumstances thereof. So she is admitting that the records are perused by her. Well, on the other hand, the plea that she is taking, that she was misguided or that the documents, whatever submission was now made, page 48. Just one statement. She is aware that these documents cannot prove the acquiring or vesting. And she is aware of this statement where she is writing, however, it is submitted that the notification under section 41A of Act 2 1948 and award of compensation of plot number 1338 are not readily traceable in the office of the special LA G Howrah. So she's aware of the entire records. This is her own statement.
Yes.
Despite that, she has constantly kept on making remarks that these records are available, where it is stated that it is to be considered whether it is vested, whether it is acquired. She could not prove. But the moment she was aware that, that this award proceeding was not initiated, forget about granting of award. The proceeding has to be initiated, and she was well aware of that. Taking all these things in consideration, and consecutively, she was granted 2 opportunities to file the affidavit. In both the affidavits, she chose to repeat the same statements where it is well within her knowledge. That can be my only submission, because after all, it is the state's appeal. And because of that, your lordship, 2003 our land was taken. 2014 the writ petition was allowed. 2014 the appeal was preferred, and it was dismissed for default. No steps were taken thereafter. In the meantime, I had preferred the contempt proceedings, where they have come up with the compliance report that now we are thinking of complying in the year 2025.
That is beyond the scope of this.
Lordship,
Happened to the contempt that is pending.
now that they have kept it pending, showing the pendency of the appeal.
We'll decide it right now.
Lordship, the suffering is that 2014 order specific direction is that you have to hand it over within 6 months.
Yes.
I'm only aggrieved by the same. Today, today their submission, entire 1 hour submission, has boiled down to cost. Your lordship, the cost was implemented for the statements which has made the writ petitioners, the private respondents. Your lordship, at the time the writ petition was filed, thereafter the writ petitioner Shanti Devi Jaiswal passed away. Substitution was carried on. They are the sons and daughters of the erstwhile writ petitioners. I'm representing both.
Good.
Lordship,
So, yes,
grateful.
Mr. Dhar, anything in reply? There is nothing to reply. Yes, at order.
If Lordship permits me, my lord, I could not, that time I could not show the Form 13 and Form 13A.
Yes. For what purpose? Form 13A has been annexed
Yes.
here. It has been annexed here. The present challenge.
13 is annexed, not Form 13A.
The present challenge has been preferred on behalf of the state authorities against a judgment dated March 7, 2014 passed in WP 8477 within bracket W of 2003. Full stop. Next para. Yes. Next para. At the outset, comma, learned senior counsel appearing for the state stroke appellants submits that the appellants would confine their arguments to the caustic remarks made by the learned single judge against the concerned block land and land reforms officer within bracket BL and LRO, and the penal action taken by her to the extent that cost of rupees 10,000 was directed to be paid by the said BL and LRO, which was to be deducted from the salary, to be deducted from her salary, and the service book of the BL and LRO was directed to record such punishment. For the next para, learned senior counsel contends that the said caustic remarks in the impugned judgment were made on the premise of 2 affidavits filed by the concerned BL and LRO. For the next para, in the first such affidavit, affirmed on August 13, 2013, the BLLRO had inter alia stated that the writ petitioner, cleverly knowing the facts that the suit plot 1338 is acquired property, and suppressing the facts and misrepresentation, took money from the B Capital Bank. Full stop. It was further stated, inter alia, that the writ petitioner admitted in the application that the case land at plot number 1338 is retained land of Huddut's HUDDUT' members, and that their allegations for purchase from the retained land of Huddut's family having no right of ownership. Full stop. The deed in question, executed in the year 1966 in favor of the writ petitioner, was alleged to be void. Full stop. Next para. The learned single judge, being dissatisfied with the said statements, inasmuch as those were not supported by sufficient documents to show that there was actually an acquisition of plot number 1338, granted another opportunity to the BL and LRO to clarify her stand by way of a second supplementary affidavit. Full stop. Next para. Such supplementary affidavit was affirmed on February 25, 2014 and filed in court. Full stop. Next para. In the supplementary affidavit, the BL and LRO stated, inter alia, that on 29/9/1964, the executive engineer, Calcutta Special Road Division, Government of West Bengal, sent a notice to the collector Howrah regarding land acquisition as per LA case number 3 within bracket Act-Roman 2 bracket closed of 1963-64, double inverted with the claiming possession, double inverted close, inter alia, of plot number 1338, and that these plots were notified for acquisition of the railway colony case. Full stop. Next para. The BL and LRO further went on to assert in such supplementary affidavit that the right, title, and interest of intermediaries in respect of plot number 1338 were vested to the state in respect of the said lands as per provisions of sections 4 and 5 of the West Bengal State Acquisition Act 1953. The next para. Learned senior counsel, arguing for the appellant, submits that the BL and LRO, in view of the documents in her possession, was under the bona fide impression that acquisition has already taken place in respect of several plots, including the disputed plot number 1338. In support of such contention, learned senior counsel places reliance on a letter written by the executive engineer, Calcutta Special Road Division on September 29, 1964 to the collector, Howrah, where it was stated that as per the proposal of land acquisition case number 3 within bracket Act 2 of 1963-64 bracket closed, the said plots may kindly be delivered to the said division. Full stop. There is an almost illegible interpolation by hand at the top right hand corner of the said communication, which apparently indicates that some authority had stated that a decision is made to hand over such possession. Full stop. Next para. To the self-same affidavit, first affidavit, another letter was annexed, which indicated that the acquisition of the plots would not be possible, full stop, in favor of the proposed project. Full stop. Next para. It is thus submitted that there was bona fide doubt in the mind of the BLLRO at the first instance as to whether the plots have been acquired. Full stop. It is further submitted that at the juncture when the supplementary affidavit was subsequently filed, the BL and LRO had come to know that the notification under section 4 within bracket 1 small a of Act II of 1948 and the award of compensation for plot number 1338 were not readily traceable in the office of the special LA within bracket G bracket closed Howrah. And she wrote as much in the said supplementary affidavit. Full stop. It was further clarified that the district magistrate and collector, Howrah, vide memo number 1168/LA within bracket G, dated 6/11/2013, wrote a letter to the senior divisional engineer within bracket 2, Eastern Railway, DRM, Howrah, for information whether plot number 1338 Mouza Bali had been acquired and taken over by the Eastern Railways. However, it was also stated in the said affidavit by the BLLRO that no reply had yet been received from the railway authorities in response thereto. Next para, learned senior counsel also brings the court's notice to the averment in paragraph 3 of the supplementary affidavit to the extent that the right, title, and interest of the intermediaries were vested to the state in respect of the lands, including plot number 1338, as per provisions of sections 4 and 5 of the 1953 Act. However, in the same breath, the DLLR also stated that subsequently Khondokhutians were opened in respect of the said plots in the name of the Hudduts as per provisions of the 1953 Act and the rules framed thereunder. Such extracts from Khondokhutians had also been annexed to the said affidavit. Next para, by placing reliance on state of West Bengal and others, reported at 1993 SUP within bracket 4 SCC 674, learned senior counsel argues that by default, by operation of the 1953 Act, in particular sections 4 and 5, the entire plots contemplated under the Act vest in the state. As an exception, certain plots are permitted to be retained within the contemplation of section 6 of the said Act. Next para, thus, proceeding on such premise, it is sought to be explained that the BL and LRO had stated in her supplementary affidavit that although at the first instance the right, title, and interest of the intermediaries had vested in the state, subsequently Khondokhutians were opened, pursuant to the applications for retention, Form B, submission of Form B by the concerned intermediaries. Next para. Thus, it is sought to be argued that the factum of retention of the lands was also mentioned in the affidavits. Next para, learned senior counsel also insinuates that the BL and LRO is not was not capable enough to have a thorough knowledge of the nuances of law, and as such, the mistakes made in the affidavits were inadvertent. It is further contended that affidavits are generally drawn by advocates and the litigant should not suffer for a misconception of law. Next para, learned senior counsel cites such and such, নামগুলো such and such গুলো বসিয়ে দেবে, reported at 1996 6 SCC 234, where the Honorable Supreme Court had observed that the tests for incorporating disparaging tests for dealing with the question of expunction of disparaging remarks against a person or authority whose conduct comes in for consideration before a court of law is to be tested on certain yardsticks, niche para, small a, whether the party whose conduct is in question is before the court or has an opportunity of explaining or defending himself, tar niche para, small b within bracket, whether there is evidence on record bearing on that conduct justifying the remarks, and next para, small c bracket, whether it is necessary for the decision of the case, as an integral part thereof, to advert কি লিখেছে animadvert কোন যা আছে তাই করে animadvert ANIMA DVERT on that conduct. Full stop. Next para. Learned senior counsel next cites the judgment of such and such reported at 2007 3 SCC 587, where the Honorable Supreme Court reiterated the proposition laid down in Dilip Kumar Deka, DEKA, bracketed Supra. Full stop. Next para. The appellant's next cite such and such reported at 1963, AIR 1964 SC 703, where it was observed that the High Court has inherent power to expunge remarks made by itself or by a lower court or otherwise to secure the ends of justice, which view was corroborated in such and such reported at 2023 20 SCC 113. Full stop. Next para. Thus, it is submitted that the caustic remarks made against the BLLRO may be expunged and the penal action taken against her in the impugned order may be set aside. Full stop. Next para. Learned counsel appearing for the writ petitioner stroke respondent submits that due to the pendency of the appeal, the writ petitioners are suffering inordinately. Full stop. Even a contempt application had to be preferred by the writ petitioners stroke private respondents. Full stop. Next para. Upon hearing learned counsel for all the parties, we come to the following conclusion. Full stop. Next para. The premise of the caustic remarks made by the learned single judge were the two affidavits which are before us. Full stop. From the said affidavits, at least from the first one, we find that there was ample reason for the learned single judge coming to its conclusion that there might have been an attempt by the concerned BLLRO who affirmed the said affidavits, to mislead the court inasmuch as the alleged acquisition of plot number 1338 is concerned. Full stop. Next para. For example, in the first affidavit, affirmed on August 13, 2013, the BLLRO categorically asserted that the deed in question executed in the year 1966 is void, on the premise of her further statement that the BLNLRO, Bali Jogacha in charge had mistakenly allowed mutation in the name of Shanti Devi Jaiswal, bracketed the writ petitioners, for revenue purpose only, and the said mutation creates no title and possession in the case land at plot number 1338, and whereby admittedly the colony persons, double inverted with the colony persons, about 500 members were residing, having no nexus with the state respondent authorities. Full stop. Those 500 members, it was stated, residing on the plot were not lawfully settled by the alleged respondents. Full stop. Next para. Again, in paragraph number 4 of the affidavit, it has been boldly asserted that the writ petitioner, cleverly knowing the facts that the suit plot 1338 is acquired property, double inverted is acquired property, double inverted close, and suppressing facts and misrepresentation, took money from the bank. Thus, it was categorically given out by the BL and LRO that the writ petitioner had made a false statement as to the plot number 1338 having been acquired. However, we find from the annexures to the said affidavit itself that the said averment is belied. For example, in the communication dated September 29, 1964, the executive engineer of the Calcutta Special Road Division merely wrote to the collector Howrah seeking possession of the subject plot being given to the said executive engineer, upon which a subsequent letter by the collector stated that the acquisition of the plots would not be possible. Next para. Hence, the BL and LRO, definitely, ought to have been much more careful in making her averments in the first affidavit, which were belied by the annexures to the said affidavit itself. Full stop. Next para. In the second, that is the supplementary affidavit, comma, the BLLRO again reiterated that the right, title, and interest of the intermediaries were vested to the state in respect of the lands as per the provisions of Section 4 and Section 5 of the 1953 Act. Full stop. Although the said statement was sought to be alleviated by the very next sentence to the effect that Khondokhotiyans were opened in respect of the said plots in the name of the Hudduds as per provisions of the 1953 Act, comma, fact remains that the rider of the Khondokhotiyans being opened is much more vague and do not categorically make out that the concerned plot, that is 1338, was retained by the predecessor in interest of the writ petitioners. Whereas the earlier part of the statement boldly declares that the right, title, and interest of the intermediaries were vested to the state. Full stop. Next para. Although in the rest of the supplementary affidavit, comma, an attempt has been made by the BL and LRO to explain away her first affidavit by stating that the award of compensation for plot number 1338 or the notification under section 4 within bracket 1 small a leading to the same were not readily traceable, comma, as also by producing a letter which indicated that an information was sought from the Eastern Railway as to whether the land was acquired, to which no reply was given by the Eastern Railway, comma, there is no categorical averment seeking to withdraw her previous allegation that the plot has not been acquired, comma, in unequivocal terms. Full stop. Even in the supplementary affidavit, comma, an attempt was made to fudge, FUDGE, the averments made in the earlier affidavit by seeking to confuse the court, comma, by making contradictory allegations. Full stop. For example, comma, even in the first affidavit, comma, in the same breath, the BLLRO asserted that the writ petitioner suppressed the fact that suit plot number 1338 was an acquired property, while on the other hand, categorically admitted that the plot number 1338 is a retained land of Huddut's family members, comma, which necessarily implies that such retained land would go outside the ambit of the vesting. Full stop. Next para again, comma, the BLLRO had annexed documents to her first affidavit, which themselves go on to reveal the truth as to there being no conclusive evidence of acquisition. Full stop. Even in the second affidavit, comma, the BLLRO has not unequivocally admitted her mistake in the first affidavit by seeking to resort to the subterfuge of stating that the records were not readily traceable and a vague remark that no reply had been given by the railway authorities on a query as to whether the land had actually been acquired, comma, without categorically explaining away her remarks as to the acquisition having taken place in respect of plot number 1338. Thus, comma, the element of bona fides is completely missing in both of the said affidavits, in as much as giving the correct information to the court is concerned. Full stop. Thus, comma, in that regard, comma, we completely agree with the learned single judge to the effect that the block land and land reforms officer had made wrong statements deliberately by intentionally affirming affidavits before the court to be true to her knowledge, comma, which averments were not supported by any relevant document, within bracket, rather, comma, belied by the annexures to the affidavits themselves. Bracket closed. Full stop. Next para. However, comma, at the same time, comma, we are of the opinion that some amount of lenience ought to be shown to the concerned block land and land reforms officer, inasmuch as the said officer is not supposed to be thoroughly acquainted with the
nuances of legal nitty-gritties. Full stop. Next para. At the same time, comma, we cannot uh, uh, cannot overlook the fact that the affidavit was in crisp English language, comma, obviously drafted by an advocate who was also posted with the annexures which were supplied with the affidavits. Full stop. Thus, comma, the entire blame cannot be cast on the BL and LRO alone, but also partially to the misconstruing of law by the concerned learned advocate. Full stop. Be that as it may, comma, it is beyond the pale of the present appeal to consider as to the role of the learned advocate at the relevant juncture. Full stop. Fact remains that misleading statements were made. Full stop. However, comma, at the same time, comma, in the very same affidavits in which the misleading statements were made, comma, the concerned BLLRO also made statements which were contradictory to such misleading statement as to acquisition of plot number 1338, comma, clearly also indicating that the said plot was retained by the predecessor's interest of the writ petitioners. Full stop. Thus, comma, some amount of the sting, STING, out of the said misleading statements is taken out by the mitigating factor that the fact of retention was also mentioned in the affidavits themselves. Full stop. Next para. Hence, comma, on a composite reading of the matters before us, comma, we are of the opinion that the insofar as the judgment of Suburban Agricultural Dairy Supra is concerned, comma, the same does not have a direct bearing on the present case. Full stop. It was postulated there that by virtue of sections 4 and 5, there is automatic vesting subject to the exceptions under section 6 of the 1953 Act. Full stop. In the present case, comma, when the affidavits were affirmed, comma, the BLLRO was sufficiently posted with facts to know that the so-called automatic vesting with regard to plot number 1338 was not the final position of the matter by virtue of the retention which had taken place in respect of the self-same plot by the intermediary, comma, which should have been categorically stated in her affidavits. For the next para, insofar as the judgments pertaining to the tests regarding expunction of adverse remarks is concerned, comma, we find that all the tests are somewhat met substantially met in the present case. Full stop. Here, comma, for example, comma, the BLLRO whose conduct is in question was given an opportunity of explaining herself by filing a supplementary affidavit. Full stop. Secondly, comma, there is evidence on record in the form of the annexures to the affidavit themselves bearing on the conduct, comma, rather than justifying the remarks, comma, belying the same. Full stop. Furthermore, comma, the factum of acquisition of the proceeding was not only necessary for the decision of the case, but was an integral part of the adjudication. Full stop. Next para. In the matter of State of Punjab and another versus Shikha Trading Company Supra, comma, which has been cited by the appellants themselves, comma, the Honorable Supreme Court had observed that the power of expunging remarks must be exercised with care and circumspection, since it is an undefined power and is to be exercised only to remedy flagrant abuse of power. Full stop. Going by the said test, comma, we do not find as such any flagrant abuse of power by the learned single judge in imposing the costs of rupees 10,000 on the concerned BL and LRO for having made deliberate and incorrect statements before the court. Full stop. In the event the BLLRO was in doubt as to the correctness of the factual matrix, comma, it was open to the BLLRO to clarify the same in her affidavit itself, comma, which was not done. Full stop. Next para. However, comma, insofar as the portion of the impugned order is concerned with the reflection of the punishment in the service book of the BL and LRO, comma, we are of the opinion that the said
component of the punishment would be rather disproportionate with the offense committed by the BLLRO in view of the mitigating factors we have discussed immediately herein above. Full stop. In such view of the matter, comma, MAT 718 of 2024 is partially allowed, comma, thereby modifying the impugned judgment dated March 7, 2014, passed in WP 8477 within bracket W of 2003, to the extent that the same directs the service book of the concerned block land and land reforms officer to record the punishment meted out to her by virtue of the said order. Full stop. However, comma, we make it abundantly clear that we affirm the rest of the impugned judgment, comma, even apart from the merits, comma, regarding the award of cost of rupees 10,000 on the concerned BL and LRO, and the direction on the DL and LRO to deduct the said amount from the salary of the BL and LRO, comma, if she does not deposit the same. Full stop. In view of the pendency of the appeal for so long and the stay operating in favor operating in respect of the impugned order, comma, we extend the time for depositing the for paying the cost by the DL and LRO to the writ petitioners till December 15, 2025. Full stop. In the event the costs are not paid to the costs are not paid by the BLLRO within the said period, comma, the same will be deducted from the salary of the BLNRO for the month of January 2026. Full stop. No orders to cost. Urgent certificate. Thank you. Yes.
Habilitation to the exposure in concursion. The petitioners that
Where were you for so long? You heard the matter, past judgment. Sorry, nothing. Yes. Call on the next matter. Yes.
Item number 9.
Yes, Mr. Bandhavadar.
I'm led by Mr.
Yes. What have you done? So Bandhavadar has come up in.
It was hard, this matter. In fact, it was part hard.
I took on adjournment.
Achha.
It has been delayed by several months.
It's Bandhavadar versus Banerjee. So the classical one means.
It was part hard. Then,
Oh, those ones.
yes, that is right.
You just given an nutshell, Mr. Bandhavadar, what was
Right,
for my learned brother.
But in fact, on that,
Yes. Yes. Sorry.
on that very day, two matters were hard. Mr. Chaturvedi was arguing on the
Yes.
same issue that your lawsuit already delivered judgment, which is in my favor. So,
Have you got a copy of the judgment?
yes, yes.
That will be necessary because.
Yes, I have also supplied him a soft copy of that judgment. The principles will be more or less same. But the only certain factual difference that I will just find. But here, this is a. Oh, my
Wrong judgment?
No, my learned junior had handed over 2 judgments delivered by your lordships, my lord, which was one is Nityanando, another is my lord Sabina. No, this is a bunch of judgments. Your lordship probably has got 2 judgments, and my lord.
Yes, very. Now rectified.
Now rectified. Well, there is a grant of mining for Blackstone mining.
One is just Mr. Chaturvedi's judgment is this one.
Both are Mr. Chaturvedi's judgment. One is earlier one, both by your lordships. One is a month earlier.
All right. Following the same must be.
Same. But the petition, my lord, initially applied for this mining lease, my lord, it was when the 2002 rules was.
This was also sand mining.
No, Blackstone mining.
Blackstone mining.
But 2002 rule was survey. My lord, there was a sanction of grant of lease, my lord, that took place on 7th of March 2013. That 2-3 dates, my lord, only.
This was a sanction of
the sanction for grant of lease was made on 7th of March 2013.
All right.
Because 2002 rules says first sanction, then execution of lease. Apply compliance, there are many formalities, environmental clearance and other formalities.
Yes.
Ultimately, this lease deed was, after every clearance lease deed was executed on 2nd of May 2019. But as per 2002 rules, since the grant was in 2013. That was for 5 years. This was for the lease, original lease was for 5 years.
Yes. Yes.
But it contained a renewal clause.
এই মাইন্স এন্ড মিনারেলস রুলসটা দিন তো ওয়েস্ট বেঙ্গল মাইন অর মাইন্স এন্ড সকালে
You also was checking it.
Yes, সকালে দিচ্ছি
I got copies also.
No, we have copies with it. না এটা না এটা
Both rules, I'll show both rules. What is 2002 rules and is 2016 rules?
2002 rules টা কি এখানে this contains 2002 rules also.
I don't have knowledge. And
this contains the 2016 rules.
16.
2002 rules. Right. Yes, sorry, please.
The lease was granted as per the prescribed format in 2002 rules, where it contained renewal for one time.
Oh, this was that matter of renewal, whether renewal comes with
61 rule 61, 62 applied. The secretary says that in view of rule 61, 62, cannot have a renewal.
Come to 61, 62 directly first.
But that is 2016 rules.
Yes, 2016 rules. এর মধ্যে ইন্টার এক্সামে কি হলো লিস্টে আগের স্যাংশন অনুযায়ী পেয়েছে আগের বছর স্যাংশন অনুযায়ী এর মধ্যে 2016 চলে এলো যতদিনে দিল তার মধ্যে ল্যাঙ্গুয়েজটা দেখুন all
61 is your lawsuit has clarified in your lawsuit judgment. One is for grant. That is declarations of ineligibility of the pending minor minerals applications for mining lease, including the applications of reclassified major. All applications for mining lease of minor minerals, including the reclassified minor minerals by such and such, received prior to giving effect to these rules, irrespective of its durations or pendency, shall become ineligible. Then, provided that if the applicant has been issued a grant order or letter of intent or any other government order requiring the alterations of the applicant's position, then his mining lease application may be considered after due compliance of all necessary conditions.
We considered this along with 62.2.
62.
62.2 that any action taken and all.
Yes.
So we said action was taken by grant of the lease or sanction previously.
That was lease. Now it is covered by the lease deed. Lease says one-time renewal.
Yes.
So that has not been overridden. Now the learned singular says 61, you had no grant in your favor for renewal. So now it cannot be done. The secretary order was not in so many words, but it says that in view of 62, no renewal can be granted. Now, YLOC has taken this rule 2016 rules. Kindly take 36, rule 36. Now, I need
2016 rules.
16 rules. Because it also saved my right. Even under 2016 rules.
Yes. Yes. You argued this.
Yes, I had argued. YLOC had taken note of these arguments.
Yes, yes. Oh, yes. Right.
I also had taken note of all these arguments.
Yes, yes. Mr. Banerjee had also started.
No, I had in fact completed my submission.
Right.
Rule 36 I had shown to you.
Yes, rule 36, 62, everything. Anyway, let us just.
Yeah. Now, rule 36 just come back. I'm just.
Yes.
Prospective license come mining lease holder or mining lease holder. What are the
two categories?
Two categories or mining shall have rights as provided in the deed of prospective mining prospective license come mining lease and deed of mining lease respectively.
Yes.
May I just read again?
Like,
Rights of prospective license company or mining leaseholder. These rights have been protected under 36. Now, even under these new rules, prospective license company leaseholder or mining leaseholder shall have rights as provided in the deed. Then just of prospective license or lease deed. So, because 2016 rules clearly saved my right, so far as one renewal, I cannot have successive renewal. One renewal, which was there under the old lease deed, that is saved even under 2016 rules. And it is not overridden by 61. 61.
Because this right of renewal was there in your deed, which is protected by section 36. So this read with 62.2 gives an obvious answer.
Obvious. And rule 61 has no application because rule 61 is applicable
new.
Only new
application.
Fresh grant.
And Mr. Banerjee, not Mr. Banerjee, then the state had argued probably in the previous matter that since the new regime had set in,
yes, all
there was
these
no
arguments.
scope of renewal any
Yes,
further.
all these arguments.
Everything has to be under the
all
new.
These arguments, and your lordship had dealt with. In fact, your lordship followed the earlier judgments of Justice Jyotirmoy Bhattacharya.
Yes, Justice Bhattacharya's judgment had been cited.
Yes.
61 includes no application for renewal also. That was the argument in the other matter.
Yes.
Also
right. We have also gone through the judgments.
And now, another fact, my lord, this is additional to this.
Why don't you bring all these matters together so that we pass one judgment? We'll have to copy paste so much portions and paraphrase.
There's already delivered judgment.
Subject to hearing, Mr. Banerjee, of course.
Now,
he may shed a new light.
Additional factor here is, my lord, I'm just showing the clauses. My lord, the lease deed starts from page 86. Kindly take page 86, it starts.
Yes.
Period of lease will also find from page 88. Page 86 lease deed starts, it is under 2002 rules as per the 2002 form. So get it at the top. See rule 24(1) of the West Bengal Minor Mineral Since 2002.
Yes.
Got it?
Yes, got it.
Then 88, let's see, in the second paragraph, let's see, find the period for a term of 5 years. After 10-15 lines in the second paragraph, 88, page 88, let's see, extreme right hand side, you will also will find this number 5.
Yes,
that is the 5 years period.
Yes, right. 5 number. Yes. Right.
This is 5 years period.
Yes.
The renewal clause is page 102.
Yes. Renewal clause. Renewal possible.
Yes, clause 3 is under chapter 7. The mining lease shall be renewable for one period of not exceeding the period specified in sub-rule 1 or 2 at the options of the lessee or lessees. So renewal was at my options. Only conditions I need to apply 6 months prior to expiring. That I had applied, nobody questioned. And this rule 12.1, it says that for the original period. Renewal for one time for original period.
Mr. Banerjee, since you are appealing for the state, do you have any idea whether these judgments were challenged before in forum?
No, I'll have to take instruction.
Because if we don't know, I mean, there might, if some other view has come, then it will be difficult to follow.
Of course, this matter, we shall try to argue that not factually that the
no, that also we'll hear you. In the meantime, if you
I'll try to answer.
Probably can't finish today, then if you can't finish today, then you just take instructions. Yes.
Now,
yes. What else, Mr. Bandod?
Yes, just. My application I have filed for renewal on 30th October 2023, page 199.
October
2023.
23.
Because it was supposed to expire on 31st May the 5 years period in 2024. Now, if you want to kindly take 2002 rules 12. Once. As well as 12. One is, my lord, an application for renewal of mining lease shall be made to the state government or to an officer duly authorized by the state government in behalf of the last 6 months. That means lease is due, expire, but not before 9 months. Such and such, this was the conditions.
Sub-rule 2 was almost bodily lifted in your
Yes,
your lease deed itself.
Yes. For one of the original lease period.
Yes.
Then Mala sub-rule 6. I will join 6.
Yes.
If an application for renewal of mining lease submitted to the receiving authority within the time as referred to in sub-rule 1 is not disposed of before the date of expiry of the lease, the lease shall be deemed to have been extended for a further period of 6 months or period ending with the date of receipt of the orders of the state government thereon, whichever is shorter. So there was a deemed extension of 6 months. Now, it was not, our application was not disposed of. We came before this court. Now, Honorable Justice Shubhra Ghosh passed an order, my lord, on 12th of June 2024. Kindly take, my lord, page 225. 22nd of June to 225, my lord.
Yes, 225. Achha, inclined to have an extension for 6 months.
For 6 months.
By default clause, clause 12.
By default clause. So the Honorable Justice, the learned single judge also found that I am entitled this benefit under Rule 12 of the 2002 rules. And so far as this portion is concerned, 12.6 was final and it was complied with by them. They didn't challenge this order. It was complied with. Then, but what, they didn't say that I will not be entitled for this. They accepted this, that I was entitled for the renewal even under Rule 12 and 12.6 they had granted me pursuant to the order of the High Court.
All right.
Now I'll just show the order of Special Secretary and the learned single judge. 235 is the Special Secretary's order. Kindly straightway take to come to. No, that was my written submission. Sorry, the order is at page 250.
252 is the.
Yes.
6 is the.
252. 61 and 62 only relied on rejected.
Yes, sir.
And the learned single judge order is 266. It says since there was no grant, 61 2 applied. Proviso 61, you are not entitled to.
Yes. Proviso 261 is on a different footing, apparently.
Absolutely. Now, the learned single judge has said,
yes,
kindly take the relevant portion.
And proviso is linked to the main section. Main section deals with applications.
Now, paragraph 17, page 271, that is the exact observations made by the learned single judge. কি পেনাল্টি প্রসিডিংস এর কমিশন করবে না? পেনাল্টি প্রসিডিংস এর কথা বলবি তাহলে আমি আগেই বলে রাখবো। ওখানে তো ডিমান্ড নেই, এখনো ডিমান্ড আসেনি। অ্যাপিল করেছিলাম, অ্যাপিলে আবার রিমান্ড করেছিল।
তখন বলবে
Paragraph 17 as well as got it.
Here only the section 61 is just
Because the learned just proceeded, the renewal will also come
under that,
under
61. But this speaks about applications for mining lease, not lease.
for the fresh grant, on the
All
first time grant.
applications for, and we also distinguish probably the language between the language.
between
Renewal
the-
separate, there's a
Now,
language.
one aspect in the
2002, there's a
the
separate.
judgments delivered by your lordship didn't consider Rule 36 and
No,
both the
no, we did
judgments.
not. Right.
So if
So
we
that was an additional argument.
that is the additional argument.
36 also gives that
36 has saved my right.
specifically.
Specifically, even if it is argued that the 62(2) doesn't save me, but this 36 has specifically saved me
All right.
because it is my existing right under the rules, under the lease deed. That has been saved under Rule 36 of 2016 rules.
Yes.
Even if it is argued that the sub-rule 2 of Rule 62 is not applicable, even then, 36 has categorically and specifically saved my right. Because this is as per my lease deed. Lease deed says one-time renewal.
Yes. Because the language is prospecting license or mining leaseholder.
Or mining lease. I'm
Got a mining
mining leaseholder. These are, because all judgments I can give the Shopon shortcuts.
Those are referred here in these judgments.
Yeah, those are referred here. I can supply the copy.
Because supply Justice Jyotirmoy Bhattacharya's judgment.
Copy. But you also have quoted the relevant
We
portion
have quoted the relevant portion. That is what we are saying. Anyway,
in both the judgments.
other judgments need not be. This is the most important. But ये के আনা ঠিক আছে অন্য পেন আছে ঠিক আছে
If anything to be added, my lord, after
he
in
is
reply.
in reply. Yes. Yes, sir.
Factual difference
Yes.
with the other two cases. Firstly is this, my lord, that Rule 62 will not apply here because in both cases, my lord, the lease was granted under the 2002 rules prior to coming into force of the 2016 rules.
Here only sanction had been meant.
Here no, only sanction was there, my lord. Then 2013, then my lord, lease deed was executed in 2019. So,
but in the lease deed, it's written
action taken. In my humble submission, if a lordship not kindly comes to Rule 62 once, what is saved is notwithstanding such repeal, anything done, any action taken, or any prosecution started under the said rules shall be deemed to have been validly taken, done, or started. In my humble submission, what action taken in this case would be the letter of intent or the 2013 permission granted under which he had to fulfill certain criteria, obtain licenses. After that, in 2019, when the lease deed is executed, then it was the execution of the lease deed was not an action taken under the 2000.
No, but wasn't it a logical culmination of that 2013 sanction? It was only a culmination of that exercise. So the action was taken under.
Action was only letter of intent. The lease deed, in my humble submission, which was not.
Lease deed is a continuation of that process.
It was not conditional. They had to fulfill certain conditions. Upon fulfillment of the conditions, only the government.
But it is granted by virtue of that sanction and under the 2022 rules. It's stated in the lease deed itself.
True, Milord. But in my humble submission, Milord, unless Milord the contract is entered into, Milord, it cannot come within the category of action taken. Anything done is not covering action taken. He is relying on action taken.
Execution of the deed in 2019, my lord, cannot be action taken under the previous rule, my lord.
All right.
Because by that time, my lord, the rule was gone. So what he got the benefit of action taken, he got the benefit of 62(2) once. Because LOI 62(2) as well as not kindly come 61. 61 provides also says, provided that if the applicant has been issued a grant order or letter of intent or any other government order requiring the alteration of the applicant's position, then his mining lease application may be considered.
As a question of altering his position and all this.
In this case, he has not applied, he has obtained the licenses in 2000 under the previous rules.
So Proviso is on a different footing.
61 favors him. Under 61, he was granted the license.
Yes.
Because of the fact that he had already applied, he had already changed his position by obtaining other licenses.
The original license, that's right. Yes.
Paying the other fees.
Yes, yes.
So 61 proviso protected him. That is why the lease was granted.
Achha.
It is only not a special benefit accrued not from rule 61 that the lease was granted in his favor. Although not the rule had gone.
Rule 2 saves this.
And 62(2) also saved the letter of intent or not grant, which was the action taken, and he got the benefit by way of the lease deed. So by virtue of proviso 61 and 62 subsection subrule 2, he got the benefit of the lease deed, which is not continuation of the process, because otherwise had the protection been not there, he would not have got the lease deed. Because
all right. So he cannot impose a double legal fiction.
Double, because he's getting a double benefit then, which is not there in the rule.
All right.
It is an action contemplated under the previous rule, not the action taken under the rule. The lease deed is an action contemplated, subject to fulfillment of conditions, which he subsequently fulfilled in 2019. So it is action contemplated, not action taken. So next, my lord, stand is rule 36, my lord. Rule 36 in my humble submission, my lord, deals with lease deeds granted under this rule, my lord, not 2002 rules. I am just going back to rule 36 once. Rule 36 says, my lord, prospecting license ka mining lease holder or mining lease holder shall have the rights as provided in the deed of prospecting license ka mining lease and deed of mining lease respectively.
Mining lease granted under these rules.
Prospecting is no longer there, but mining lease is there.
Lease is there.
Prospecting was not there previously, but mining lease is still there.
2(1)(e) defines, my lord, mining lease.
2016 rules.
Yes, we were searching for that actually.
It was also on the submitted. I had shown the definitions, my lord. You'll also recorded under the 1957 Act. And the definition is as per 5th Act. I have given the reference on the last occasion also.
Now, lordship kindly comes to the 2L.
2(1)(l).
2(1)(l)
of the 2016.
Of the 16 rules. Lease means a mining lease granted under these rules. In my humble submission, when rule 36 refers to a mining lease, it is a lease under these rules. So this rule 36 is not saving any right under the 2002 rules. Any mining lease granted under 2 rules, that is not saved by 36. Now
rules আলাদা করে defined আছে ওখানে আলাদা করে defined আছে.
Now lordship will kindly, I am just shortly pressing the impugned order in the writ petition, my lord. The reasoned order passed which was impugned.
So then what would be the effect of 36?
36, my lord, only the leases granted under these rules
shall have rights as provided in the deed of prospect and so just the rights of mining leaseholder is as per the deed, as per the lease deed.
So under these rules, if any lease is granted,
so what was the use of introducing this? Then obviously they have rights as per the deed.
As per the deed, so
it's like saying lessees have rights in terms of the lease deed.
Not have any extended meaning, to give them any benefit under the previous rules unless expressly granted.
Why was this required at all? I mean, why should I say in a statute that a lessee is entitled to the rights given under the lease deed? Obviously, that is the purpose of a lease.
True, if a rule is prescribed in the put in the statute book, but without reference to any previous rule, in my humble submission, the benefit of extension to the previous rule possibly cannot be granted.
An umbrella section giving the right to.
This is a general section that you. not necessary because all the lease deed conditions are contractual rights between the parties.
Exactly. Yeah.
Statute.
Anyway.
Now, my lordship will kindly.
But since lease has been defined here specifically to be a lease under these rules, therefore.
Now, in this case, my lord, the impugned order before the writ court, my lord, that categorically records, my lord, the reasons that the action taken was under the 2002 rule. The action taken is not the grant order.
Sanction.
The lease. I'm just, I'll just place the reasoned order once, then I'll go to the page 250, my lord. We got up order dated the 7th of May 2025. Start from page 250, my lord.
The High Court's order?
No, order not passed by the authority rejecting his
yes,
renewal in terms of the Honorable Court's order.
First round.
Yes.
Now, paragraph 3, facts. Provisional grant order for mining of Blackstone was issued in favor of the petitioner, Sukriti Pebbles, filed memo number so and so dated 7th March. Consequently, the lease deed was executed, which was registered on 2nd May 2019. Tenure of the lease was for 5 years. Expiry date being 1/5/24. So these two dates are important. Grant order 13, lease 19.
Yes.
Sukriti Pebbles submitted an application on 30/10/2023 before the ADMLRO for renewal of the lease stated above, and the said application for renewal was transferred to the mines branch of the Department of Industry, Commerce, Enterprises for consideration. Sukriti Pebbles filed writ petition. Then the order of the Honorable Court is quoted. I am skipping this part. Then lordship will kindly come to paragraph 6. Thus, paragraph 6, page 252.
Yes, paragraph 6.
The submission of the lessee stated above has been examined in the light of MMDR Act 57, West Bengal Minor Mineral Rule 2002, and Minor Mineral Rules 2016, and all the points mentioned in the written submission of the petitioner. The deposition made by the petitioner and others present at the time of hearing was also taken into account. From the documents on record, it appears that the lease deed in the instant case was executed after the West Bengal Minor Mineral Concession Rules 2016 came into force. The rules of 16 expressly repealed the West Bengal Minor Mineral Rules 2002. Rule 61 of the 16 rules, however, provided that the case of LOI was granted prior to the coming into force of the 16 rules, then the mining lease application could be considered by the state government after due compliance of all the necessary conditions. The lessee in the instant matter was allowed LOI in 2013, and his application was considered by the state government in the Department of Industry, Commerce and Enterprise in terms of Rule 61 of the 2016 rules, and subsequently the lease deed was executed in the year 2018. In my opinion, this action of the state government in granting the mining lease and execution of lease deed does not create any right in favor of the lessee for further extension of the lease upon expiry of the original lease period. From a plain reading of Rules 61 and 62 of the 2016 rules, it can be logically inferred that while intending lessees who were granted LOI prior to coming into force of the Rules 16 rules could be considered for grant of lease under Rule 61 of the 16 rules, no such express condition has been put forth to establish their rights for subsequent extension or renewal of such leases. Further, Rule 62(2) of the 16 rules validates only those acts which have been validly done, taken or started under the 2002 rules at the time of enactment of the 2016 rules. The prayer dated 30th October 2023 for renewal of mining lease not being an act initiated at the time of enactment of the 2016 rules, effect date is 29/7/2016, being the date of publication of the 16 rules in the Gazette, is thus not covered under Rule 62(2) of the 2016 rules. In view of this, I am of the opinion that the prayer of the petitioner for extension of lease granted in his favor is devoid of merits. The prayer of the petitioner is thus considered and rejected. So, the first point that I submitted also was taken in the order impugned in the writ petition. Now, the next point is that they say that in view of clause 3, renewal clause is there at the option of the lessee, so it's an automatic renewal. There's a vested right which cannot be taken away. That is the second submission made. Now, I'll go back to clause 3, Millard.
Page 202.
At page 102. In my humble submission, although it starts with option of the lessee, but the entire clause has to be read as a whole to see what is the intention of the clause. It is not that a unfettered right is given to the lessee that once you apply for extension, you get it. There are some leases where expressly only on application or option of the lessee, renewal is automatic. This is not such a clause, although the term option of the lessee is used. my learned senior friend has relied on a judgment on the previous occasion, 2014 one Supreme Court cases. In that judgment also, the Honorable Supreme Court says the language of the renewal clause has to be seen to gather the intention, whether it's absolute option of the lessee or both parties. Here, my lord, I would say his only right, vested right, is to make an application, ask for renewal. But the renewal is subject to, my lord, the conditions of clause 3.
How do you explain this deeming clause that if in 6 months you don't respond to that, it's automatic renewal? For 6 months. Within a limited period, if you don't respond, it's automatically renewed for 6 months. So that's automatic then without any compliance.
That was granted by the court under Rule 12. Although I'll be submitting.
No, we are asking, yes, right.
That Rule 12, once Rule 12 is repealed, my lord.
2002 is repealed, therefore Rule 12 cannot
12
come.
is also not there. The Honorable Court, although granted deemed extension, that should not have been granted. Because if 12 is not there, my lord, then 12(6) also goes.
Maybe.
There was no question, but they got the extension.
Maybe. But you did not challenge that. But no estoppel against the law.
Now, my lord, now, my lord, in the other cases, my lord, your lordship, my lord, distinguish between under the rule and in accordance with the rules.
Yes.
Because in those cases, your lordship not held, after going through the least read of those cases, that entire Rule 12 is imbibed in clause 3. So, although Rule 12 is gone, in essence,
by virtue of the clause, it should.
3 is the contract, and entire Rule 12 is there. So, in accordance with Rule 12, it could have been considered. To that matter, I have a humble submission. I request your lordship, if we compare clause 3 with Rule 12, although some of the subclauses are imbibed here, or not all the subclauses. So it is not an exact replica of Rule 12 in clause 3. If that be so, it cannot be said that not entire Rule 12 is imbibed.
Let us see whatever is here, whether that is on the important aspects, whether that is similar to Rule 12. For starters, that default clause is not there. Rule 12(6) clause is not there. That it will be a deemed
is not.
That is not there.
There are several subclauses which are not there.
Not there. No,
they will be arguing section 56.
No, not that 12 was bodily lifted into this renewal clause, but the relevant portions.
Some portions have been brought in.
Let us read this rule once.
The mining lease shall be renewable for one period, not exceeding the period not specified in sub-rule 1 of Rule 12 at the option of the lessee or lessees. Provided, however, that the state government may refuse to renew a mining lease over the whole or part of the area covered by the original lease.
So this right of refusal is there.
Right of refusal is there, they have to only give reasons. That is in the rule. Here it is not there.
No, it is not there.
Rule 12 says
can outright receive
that after recording reasons for such request.
Here it is not there.
That is not there. So there's absolute right of refusal also. Absolute right. Without giving reasons.
All right.
As compared to the rule which says with reasons you have to read.
Right.
Then next, if the lessee be desirous of taking a renewed lease of the premises hereby demised, or any of the part or parts of them for a further term from the expiration of the term hereby granted, and is otherwise eligible, he or they shall, prior to the expiration of the last mentioned term, give to the state government 6 calendar months previous notice in writing, and shall pay the rents, rates, and royalties hereby reserved, and shall observe and perform the several covenants and agreements herein contained, and on the part of the lessees to be observed and performed up to the expiration of the term hereby granted. State government, on receipt of application for renewal, shall consider it in accordance with Rule 12 of the said rules, and shall pass orders as it deems fit. If renewal is granted, state government will at the expense
this
of the
Rule 12 is referred to here.
Rule 12 is referred to.
And in accordance with
Rule 12. My submission is where Section 56 of the Contract Act. If during performance of a contract, a condition of the contract becomes impossible of performance, then that contract goes. If your lordship kindly permits me to place Section 56, Doctrine of Frustration. If Rule 12 is gone, my lord, then my lord, the scope of performance of clause 3 under Rule 12 also goes.
Law as on existing on the date of consideration will be the applicable law.
If your lordship, lord.
No, we contract.
No.
An agreement to do an act.
Not you, my other court officer. You cannot give him. Yes, Dipankar পালাচ্ছ কেন এদিকে বদমাইশ কোথায় যাচ্ছ তুমি? হয়ে গেছে, ছেড়ে দাও। Section 56.
56, Lord. An agreement to do an act impossible in itself is void. That part is not attracted because it was at that point of time. Contract to do act afterwards becoming impossible or unlawful. A contract to do an act which after the contract is made becomes impossible or by reason of some event which the promisor could not prevent, unlawful, becomes void when the act becomes impossible or unlawful.
So unlawful.
Unlawful, there is no rule.
Therefore, it's unlawful in the sense that it's
There is no law
even if
to-
not contrary to law,
Contrary to law,
but not in there is no law to support it.
no law to support it. I cannot not phrase it as unlawful because they are not against any law, but there is no law Lord, to perform because Rule 12 is not there, and not impossible because it says upon receipt of an application, it has to be considered in accordance with Rule 12. If Rule 12 is not there, my lord, and entire Rule 12, if it is imbibed, my lord, in the clause, then we can say that it's a contractual
Now,
clause.
if you say impossible, Mr. Banerjee, then if this is read with 62(2),
Fine.
that anything notwithstanding the repeal, so we have to forget the repeal for anything done in your first argument comes back. That
this-
grant was the action taken.
Action taken was the grant.
But there is a distinction. There are two expressions used in 62(2). Anything done, any action taken. What is the difference between those?
Action taken is my lord, in our submission, my lord.
Anything done and action taken is same apparently.
Action, same thing, my lord, the grant.
Anything done would be if the grant is anything done, it has been done. But any action taken,
My lord, or not
isn't it a continuation of
the
that
actions
action?
taken by the lessee pursuant to the grant of fulfilling the conditions laid down, that is also action taken by him.
All right. All
Action
right.
taken by him. So these are all actions taken. But not the moment the rule goes, my lord, maybe in a further actions, but for the release deed, my lord, in my humble
It's
submission,
a very
my
good
lord,
argument actually. Doctrine of frustration.
It is not an action taken.
it is my junior has pointed out, it's an action contemplated, maybe action.
Yes, you said
contemplated.
that. That was we have recorded.
I'm grateful. So in my humble submission, Lord, 56 comes in. So even if not Rule 12 is referred to, and some of the portions of not Rule 12 are quoted, not the entire Rule 12. So we cannot say that it's a replica of Rule 12 and the whole.
Not a replica. Not a replica.
No, because there are some conditions which are not there. 12(6) is not there, my lord. Then conditions, my lord, which are imposed in Rule 12, that you have to produce this, you have to produce that. Those conditions are also, my lord, not there in the rule. I'll just not point out, my lord. Rule 12 says.
No,
what?
there, Mr. Banerjee, you also have to distinguish our judgment regarding on that point in accordance with and under. This does not say the state government on receipt of application for renewal shall consider it under Rule 12. If it was under Rule 12, definitely Rule 12 is gone. In accordance with, why shouldn't it refer to the language of the extinct Rule 12 also? In accordance with whatever is there in Rule 12.
I'll try to distinguish from the facts of that case. Your lordship held in that.
And in accordance with is something different. If it was under Rule 12, it would be impossible. If it is not unlawful, it's not impossible either. Why is it impossible? You can do it.
If not
You
the
can
benefit of-
grant renew the license. It's not impossible otherwise. If it's not unlawful, then it's not impossible.
Lord, absence of rule, Lord, I cannot say it's an act unlawful.
No.
But, my lord, since the clause says it has to be considered in accordance with rule, my lord, it becomes impossible. So once, my lord, the clause says that the application has to be considered in accordance with Rule 12, my lord, so all the paraphernalia of Rule 12 are to be fulfilled.
The state government, on receipt of the application for renewal, shall consider it in accordance with whatever is there in Rule 12.
Rule 12. So all the paraphernalia.
So you have to
of Rule
consider
12
the paraphernalia of Rule 12 are important into this.
No, in this case, my lord, the paraphernalia is not important, my lord, because in the other matter, your lordship, my lord, recorded after going through the clause that firstly, 62(2) benefit was there, action taken. Secondly, in that backdrop, the entire, my lord, Rule 12 was incorporated in the clause. On those facts, your lordship, my lord, in the judgment of
Not entire, not entire.
Nityananda Pal, held. Place possibly, my lord. Nityananda Pal. It is already, my lord,
Yes, sir. Everything has been handed over.
only 3 paragraphs from your lordship's judgment may I place, my lord.
Yes, which paragraph just tell us?
Paragraph 40, 41, 42 up to Milord 45.
To 40?
To 45. May I just place Milord?
Hmm.
Again, later on in clause 3, it is stipulated that the state government, having received an application, must consider it in accordance with Rule 12 of the 2002 rules. The phrase used was chosen carefully. If it was intention of the parties to be directly governed by Rule 12, it would be provided that the state government shall consider the application for renewal under and not in accordance with Rule 12. Moreover, although the language of clause 3 of the original mining lease draws inspiration from Rule 12, it is a contractual term independent of the state rule. Otherwise, there would be no necessity to repeat the entire language of Rule 12 in the clause. The state clause would merely provide that the application for renewal would be governed by the relevant statutory provisions of the 2002 rules. Thus, the very language of clause 3 of the lease deed confers an independent standalone status of the state contractual clause, irrespective of Rule 12 itself. The right of renewal, thus, is not merely governed by Rule 12 of the since repeal 2002 rule, but an independent contractual right derived from clause 3 of the original mining lease.
The in accordance with logic remains the same.
Now, in paragraph 43, hence the repeal of the 2002 rules and with it Rule 12 does not have any direct impact on the subsistence of clause 3, even after such repeal on the strength of the lease deed itself. Clause 3 was a part thereof by virtue of the language of Rule 62.2 of the 2016 rules. In view of 62.2, your lordship held this.
Yes, that remains. The first argument of yours remains.
This judgment also, in accordance with rules, my lord, was on the pretext, my lord, that 62.2 benefit was there. Under such benefit, it is to be considered.
Yes, 62 has to be brought in. Otherwise, it's difficult.
62, and also, my lord, your lordship not held in this case that the rule was entirely not imbibed. I'll find that section, that provision. I'll just point out the paragraph where your lordship held that the entire Rule 12 has been imbibed in that clause, in that matter. But my humble submission is that in this case, it is not imbibed. Some portions, like not application before 6 months, that is there. But the other paraphernalia of Rule 12, like submission of certain documents, then 12.6, these are not there in the clause, in the lease deed. So, in my humble submission, they cannot take benefit of Rule 12 being imbibed in clause 3. And so far as vested right, my submission is that it is not a vested right of renewal at all. It is a right of consideration only, where the state government reserves the right to unconditionally reject. So, now, just for next,
yes.
Rule 36 I have submitted already. 36 will not apply because it was the mining lease under the 16.
Same, 2016.
Clause 6 of the General Clause Act has been referred to. Now, clause 6 will not.
Clause 6.
Section 6.
Section 6.
Section 6. Effect of repeal. Where this act or any central act or regulation made after the commencement of this act repeals any enactment hitherto made or hereafter to be made, then unless a different intention appears, the repeal shall not be.
You continue. It's better. Yes.
Affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment so repeal. Now, in this case, right, accrued, or acquired, I would humbly submit that there is no accrued right. It's a right of consideration only. Right of consideration, that there is a right of consideration, but then it goes to the second part that it has to be considered under the specific rule, which is no more there. So this right of consideration is not right of renewal, and the right of consideration is circumscribed by the other condition that under the 2002 rules, which becomes impossible to perform.
So according to you, then if that is impossible to perform, that portion goes or the entire clause goes?
That portion of consideration under the rule, maybe he might make the application. Now the parties on the state government.
Where do we draw a line? I mean, which part of this renewal clause goes?
But he is making the application is not
state government on receipt of application for renewal. You say that he can make an application for renewal. Then After that, what do you do?
After that,
Shall consider it in accordance with Rule
accordance
12.
with Rule 12.
This portion
Still
goes.
consideration part goes because
So what do you do then upon getting it?
we cannot consider it under Rule 12. So the application becomes meaningless. There's an application but we cannot consider. That is the
But he was saying that application, he has a right to make an application. But in the same breath, then you don't have a liability to consider that.
I cannot say that the rule clause 3 entirely goes.
Which
Only
part goes? It's very
only
difficult.
The part which becomes impossible to perform as per section 56.
According to what exactly will happen? They apply for renewal, that part remains. Then what do you do? Because your consideration is in accordance with Rule 12.
Due to the repeal, my lord, only my lord, the state's duty to
On
consider
receipt, shall consider it, and shall pass orders. The portion in accordance with 12 goes.
That part goes.
So this part of the sentence then becomes the state government on receipt of application for renewal shall consider it and shall pass orders as it deems fit.
Shall pass orders.
If we truncate that portion, this remains.
Which has been done.
We date it from the section, the clause itself. Minus that.
That has been done by the state government. State government has said that in view of the repeal, it cannot be considered. State government has passed an order.
That is wrong. In view of the repeal, it cannot be considered, you have said.
I
have to consider it.
In view of the repeal, my lord, the portion which is impossible of performance, that part, my lord.
But you have to consider it on merits. I mean, the renewal application. You have to consider that there is no consider. You say I am not bound to consider that even in view of the repeal of the earlier act.
My lord, the clause.
How can you say that? You altogether shut it out. You say I won't consider it.
But he is making the application, my lord. We cannot prevent him from making an application because Rule 12, my lord, contemplates, my lord, a particular.
Not only making an application, you cannot prevent someone from making an application in court. Here it's a right given under clause 3, which right you say remains. Right to make an application for renewal. If there's a right to make an application for renewal, there must be a reciprocal duty on your part to consider it. If I have a right to make renewal application, there must be some reciprocal duty on your part to consider it also. Maybe not in terms of Rule 12.
Due to operation of law, it's a contract, my lord. He will make an application, we shall consider it. Now, my lord, the consideration is not with some certain conditions.
After coming into force of 2016 rules, in 2019, you execute the lease deed with this clause in it, and you say it's impossible. Then in 2019, at the time of entering into this agreement, you had to be aware of that. You entered, this agreement was entered after 2016
in that case also 56 applies, not. If not certain condition clauses put in the contract, which is impossible of performance, or it becomes impossible during subsistence of the contract. Both situations are covered by section 56. So even if not on the date of the contract, not if the clause is put in, but in view of repeal, not that is impossible of performance, then also 56 applies. Two situations are there in 56. First part, I'll just.
Yes, just please.
First part says me not that an agreement to do an act impossible is void. Then the second part says a contract to do an act which after the contract is made becomes impossible.
That is where we are telling it's not so. It has not become impossible after the contract was entered into, Mr. Banerjee. It was impossible as per your argument when the contract was entered into at that point of time.
In that case, not the first line.
How can 56 come in?
Covers 56.
So you enter into it knowing that it is impossible. This operates if the impossibility occurs after the entering into of the contract. Here it is before the contract. 2016 Act came, rules came. You entered into the contract in 2019. Therefore, the impossibility did not happen after.
It was a clause which was put in, which was impossible. By operation of law, it was impossible of performance.
56, how does it apply? It does not become
an agreement to do an act.
See, you are by 56, Mr. Banerjee, 56 draws an exception, carves out an exception. A person has a right. If I enter into a contract with you, that contract itself confers certain rights on me and liabilities on you, and vice versa. That right is being taken away by this. This is a weak provision in the sense that this takes away a contractual right, which is honored by all law. Now, there you say that if a contract becomes impossible to perform after you enter into it, then 56 comes in. This did not become impossible, quote unquote, after entering into the contract. Because the impossibility was already there when you entered into the contract.
So that is covered by the first part of 56, my lord. Kindly see first part of 56, my lord. 61. An agreement to do an act impossible in itself is void. So both eventually the agreement, if the impossibility happened prior to the
entire agreement should go, or this clause should go.
Clause will go as per. But they should have taken care of this, my lord, but they should have taken care of this part.
Who should have?
The makers of the lease deed.
1872.
No,
Subsisting till
makers of
date.
the lease deed, my lord. They should have thought of this. my lord,
Better,
that
better
rule
argument.
12, clause 3. They should have removed the rule 12 part or not the renewal part.
They should have. They have not.
So, my lord, then 56 will apply, my lord. Parties have consciously entered into a contract.
Hmm.
Now, if the clause, my lord, is impossible of performance.
Both parties
So, my
know
lord,
the law. It is not just
on my lord, the in accordance part, my lord, I say that the previous judgment is distinguishable because 62(2) will not apply. And so far as my lord, the rights, accrued right, I submit, my lord, that it's a consideration which, my lord, in view of 56 becomes. I'm not, okay, I'll take note 5 to 10 minutes.
No, we continue. Next. No difficulty. Will not conclude. Will not hurry up. No, no, এটা আপনার বলি। এটা আপনার। ও না, না, এটা আমার। Heard in part for further hearing on December 3, 2025. December 4, 2025.
এটা ঢুকিয়ে নেবে
এটা এর মধ্যে ঢুকিয়ে দেন 1 2 টা সেভ করে জাজমেন্ট ডিসপ্লের সঙ্গে দাও।
I thought that you will continue today.
আমাদের বইটা নিয়ে
হ্যাঁ
I thought that you will say is desirous continuing today.
No, no. We are also human beings after at the end.
That's why I was.
এই নামটা দিয়ে
পেন পড়ে গেছে একটা দেখো তো পেন পড়ে তুলে নিয়েছো